A plain reading of the state instructions should show that the post of Mujadar has to be filled up by selection, which should ordinarily be from the members of the family. Clause 3 further makes it clear that in a given case, when there is no claim from the members of the family, the incumbent has to be a local resident. The qualification for such appointment has also been laid down, as per which the minimum qualification has been stated to be a fair vernacular education. It also makes it clear that higher qualified candidates would be preferred if other things are equal. There is no dispute to the fact that response number 4 is a higher secondary pass, whereas the petitioner is a matriculate. This court is therefore required to consider the submissions regarding the application of the Hindu Succession Act 1956. Learned counsel for the petitioner has given immense stress on its application to impress upon the court that the petitioner, being the wife of the deceased Muzadar, would have a preference, as she is a class 1 heir, whereas the response number 4, being the brother's son, is a class 2 heir under the state act. The overriding effect of the act has as laid down in section 4 has also been emphasized. However, the entire objective of the aforesaid enactment is for devolution of property. An appointment to the post of Muzadar cannot be equated with devolution of property. Though it is true that under executive instruction, the family members of a deceased Muzadar would be given preference, such recruitment process is an open one, and there is no question of any devolution of post upon any of the heirs of the deceased Muzadar. This court finds force in the contention of Sri Das, the learned senior counsel for response number 4, that the Hindu Succession Act will not have any application at all. Under section 3F of the Act, definition of heir is in the context of the property of an intestate. Further, overriding effect of the Act under section 4 is the context of any matter for which the provisions is made in the Act. This court is therefore to examine as to whether the considerations made by the authorities in making the appointment are based on relevant factors germane to the issue at hand. Both the petitioner and the respondent for being held to be eligible, taking recourse to higher qualification possessed by the respondent for cannot be said to be irrelevant or extraneous by any means, and such preference is recognized by the statute itself. Under the aforesaid facts and circumstances, this court of the considered opinion that no case for interference is made out. Accordingly, writ petition is dismissed. Interim order stands vacant.
Sure. For the item number 6, with consent of the other side, matter we come after vacation, I small matter, but I have one matter in put on one matter. So
this matter is of the year 2017, a short accommodation is not para considering the above, this matter for admission immediately after
16 of November.
On 16th of
16 November.
16/11.
Thank you for listing. After vacation, immediately after vacation, there is a promotion matter he's pending.
At what stage?
On the admission stage, the hearing was taken place, but after that it's let out.
Of which year?
2018.
May I please, Your Lordship? Lordship, I beg to mention item number 16, Your Lordship, for hearing. Lordship, my senior is unwell today.
16.
Yes, Your Lordship, for hearing.
2012 matter. Who is your senior?
Mr. R.C. Palil.
12 matter. Very difficult. When can he come?
Lordship, actually, he is out of station. Yesterday he has come, Lordship.
No, he is unwell, you have said. When can he come to the
If possible, Lordship, next week.
hearing next? Hearing next. It is submitted. That's the RC Pal. Have you taken the consent of the other side?
No, Lordship.
No, Mr. There are, I think,
I'm for response number 1.
one only. There are private respondents also. Mr. L. Talukdar name is there. You have to take consent of the other side. Without consent, we cannot pass any orders.
I will inform, Lordship.
You have to inform first. Get the information. We'll pass orders when the matter is. Yes. Next. Yes, madam.
May I please, Your Lordship? Lordship, I beg to mention item number 3.
3.
I'm appearing on behalf of Mr. A.T. Atya. Lordship, the petitioner had already taken the file from us and he had intention to engage someone else. So Lordship, our names will be struck in case.
What is your name, madam?
A Chatya.
A.H.
Atya.
MS A.H. Atya, does it count appearing on instruction of the A.J. Atya, does it count for the petitioner submit that the file has been taken away by the client and they are no longer the counsel for the petitioner could compare. Under those circumstances, a further opportunity is granted to the petitioner to engage any other counsel, if to advise. Sarah, please on Tuesday. If, however, there is no representation on behalf of the petition, this court will be constrained to pass appropriate.
Much obliged.
To mention item number 2, top of the list.
Yes.
I may be accommodated today. I may be taken up next.
Next week will be motion difficult. 12 matter, Purva. 2012 matter.
Yes. Unprepared.
Some difficulty.
Yes, sir.
So after the vacation. The 12 matter we don't like to adjourn like this.
Then it would be. It is better taken up at
2 o'clock. Prior to. If you have some difficulty, then like.
May I please, Lord? Back to mention item number 1. This matter may kindly taken up at 2 p.m. Lord. This case is lead by Mr. M.D. Singh. It's on the way, Lord.
Lordship, there's certain difficulty at 2, Lordship. Another division bench is at court number 1, Lordship. Matters are fixed there.
Let us have the matter. If you have a difficulty, we'll
Yes.
Right now, we cannot say can be present.
Obliged.
My lord, with regard to the item number 2, my lord, we also have some difficulty, my lord. This is the 2012 matter, though, my lord. We also don't have a file, my lord, of this. We'll have to reconstruct this file, my lord. That is the problem.
A joint prayer for accommodation has been made both by Sri S.S. Barua, Learned Counsel, for the petitioner as well as Sri R. Learned State Counsel. Consider that matter of the year 2012, a short accommodation is done by directing listing of this matter on when?
After vacation,
Fix the date on 7th of November. 7 November.
thereafter,
what is it?
thereafter, अपना file.
My praise the Lordship. This is ASCC matter, Lordship, suspension matter, that 771 candidates were suspended, Lordship. And I am, Lordship, in this list, Lordship. Actually, Lordship, what happened, Lordship? I am that person. I am, and Lordship, one Dilip Das from Nalbari. Both of, well, Lordship, my mistake included in the list, Lordship.
You were suspended.
Lordship actually said 7 terminated candidates, 771 altogether, Lordship.
Termination.
Termination, Lordship.
You were saying suspended.
No, wrong. Sorry, Lordship. Terminated, Lordship.
Yes, ACC was a Transport Department name shown or not?
Actually, Lordship, I was appointed 10 years back, Lordship, in 2013. Yes. 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 Yes.
Yes, Transport Department.
We are
ACC.
for ASCC, but we have not received the copy. Transport is MD Bora.
Have you served copies upon MD board?
Yes, Lordship, personally, I also gave a copy, Lordship, on last occasion.
Names are not reflected in the cost. That's the difficulty. Madam, you are for ACC.
Yes.
You have been served copies or not?
No, we have not.
First, Lordship, this is second time listed for motion, Lordship. Earlier occasion, Honorable Court director and accordingly,
No, but
I
Mr.
have
Nayak
copy.
name is there in the cost list.
Yes.
You are with Mr. Nayak.
No.
Madam, today, item number 4.
After some time,
But we want the sending concept transport also.
my lord, in this case, ACP deputy.
We'll have this tomorrow.
Tomorrow, Lordship.
But in spite of the direction of this court,
My
On
lord, maybe
it-
after some time.
tomorrow will pick up. The transport department council name is also not in spite of the court. By order dated 18/9/2023 to reflect the name of the learned standing council transport department because comma the name has not been reflected, comma raised me to look into this matter and raise this matter tomorrow.
On Monday, tomorrow may not be.
Monday. Raise this matter Monday. Raise this matter on Monday by showing the name of the learned standing council transport department along with the other council for the Monday.
Ma'am.
That affidavit has been filed.
Yes, we have just got it.
Where is Mr. Bhattacharya?
Maybe on next another court.
Have you gone through the affidavit?
Yes. It is
Before-
the same which was shown in the mobile.
Yes,
Paragraph 5 is the crucial paragraph.
So we had a cursory glance of the day, but we have not gone through the affidavit. You can, if you want, you can respond to the affidavit, but I think we can
No.
do it in his presence after a while.
Yes, yes. I'm here.
Mr. Chaudhary will be coming on. We think we have heard him. Our hearing is almost over. We just wanted to have the views of the
Yes.
council for the for the central government. Have the response of after some time.
Yes. No problem.
Procedural. My lord, matter relates to
Mr. Goswami, after a long time.
my lord.
Yes.
The matter relates to the appointment of a lecturer in the government Ayurvedic college, my lord, in the department of PR studies. The petitioner has challenged the appointment of responsible numbers 3 and 4, primarily on the ground that the
We
marks,
take this for final disposal.
yes, my lord.
2017 matter. Five nine zero.
Also, I was asked to produce record according to
Yes, what are the facts?
My lord, the fact is that there was an advertisement
Advertisement dated
dated 23/12/2015. Pursuant to the advertisement,
for
yes, call for filling up the post in 2 departments in the government Ayurvedic college. Those 2 departments are, my lord, Kriya Sharir, and other department is, there are 3 names, my lord, Samhita, Sanskrit, and Siddhanta. So there are 2 departments.
one is
Kriya Sharir,
where do you get the
my lord, page 13,
1-3?
1-3, my lord, at the bottom, my lord, at the bottom, what you will find,
Kriya Sharir.
right? Yes, my lord. And skipping the next one, the last one, last lecturer, Samhita, Sanskrit, and Siddhanta,
Advertisement for lecturer.
my lord, in the government Ayurvedic college.
No, not only 2 departments, various departments.
Various departments. Your lordship is correct.
You are concerned with 2 departments.
I am concerned with this department. And in this connection, my lord, I would also like to draw your the
Okay, then what happened?
my lord, the following page 14, the various criteria laid down, my lord, educational qualification, how to apply, and so on and so forth. Then, my lord, I'd like to draw your lordship's kind attention, page 15.
You are an aspirant for both these
Both-
departments.
Yes, my
Then?
my lord, page 15. Your lordship,
Page 15,
yes, my lord.
you had
How-
applied.
How to fill up the form? Now, clause C, my lord. Clause C says, my lord, I will just draw your lordship's attention to the relevant line, my lord.
Clause
C, my lord.
Yes.
Yes, my lord. In case of detection of any false declaration, so on and so forth, my lord, experience certificate within bracket where necessary should be furnished invariably. Experience certificate, my lord. This I would like to highlight, my lord, because later on we will find out, my lord, that this has been disputed by respondent number 3, that experience is not mentioned in the advertisement, but it was mentioned.
No, see, there are certain mandatory documents. Number 1, self-attested photocopies of certificate, mark sheet from HSLC onwards, and also caste certificate. Then registration certificate. Then experience certificate is where necessary. The mandatory nature is not with regard to experience certificate.
As it were.
Where necessary. Nonetheless, yes.
Yes, ma'am. Then, my lord, we all applied for the post. So, there is a petitioner as well as respondent numbers 3 and 4, we applied. Now, in the meantime, my lord,
Petitioner, respondent 3 and 4
my lord,
are applied.
my lord,
Mr. Goswami for are 3 and 4.
I am for only for 4. That's for 4.
And 3,
my lord,
who is for 3?
Mr. BK Das appears for respondent 3,
BK Das.
my lord. They have also filed a plea with disconnect.
Okay, nobody is there. Names are shown in the constitution.
My lord,
Then
what happened, my lord? My lord, in the mean, though the interview was held in the year 2015 itself, but the results were not declared. He approached this honorable court, my lord, page 17, in the year 2017 for declaration of result,
Page 17.
my lord. Lord, you'll notice in the last paragraph, lordship, honorable court is directed.
WPC 3848.
Declared the result. My lord.
WPC 3848.
3848 of 2017. While honorable court's order dated 25th of August 2017. Honorable
Dated 25/8.
8 2017.
Yes.
My lord, honorable court was pleased to direct direct the APSC to declare the result within the period of 2 weeks.
Yes.
So the following page 18, my lord, the results were declared finally,
1-8.
my lord, Annexure C.
Result.
My lord. For the post of lecturer in tertiary, respondent number 3 has been selected. And
You are a general category.
my lord. And well, I think all it's a general category postman, unreserved post. So for the for the post of lecturer in Samhita, Sanskrit and Sandhi, restaurant number 4 has been selected, for whom my learned senior friend appears, my lord. Thereafter, my lord, affidavits have been exchanged. APC has also filed affidavit, restaurant number 3 as well as restaurant number 4. My lord, from the affidavit filed by the restaurant number 4,
Mr. Goswami for R4. Okay.
from the affidavit filed by the restaurant number 4, my lord,
The private respondent.
I would like to first draw your lordship kind attention to the affidavit filed by restaurant number 4.
Now, what are your grounds?
I am challenging now the selection process matter. It was not constituted properly as per the rules.
The committee was not constituted or selection was not done properly.
Committee was not constituted, and lordship will find from the record that the persons who conducted the interview, their names have not been mentioned in the final selection list.
Whose names?
The persons who interviewed the candidates in the year 2015. The results were declared in 2017, but some other person, the names of some other person are there in the 2017 list. It will be apparent from the records, my lord. We have once the records were produced.
Are you trying to say that the interview was taken by somebody else, results were declared by somebody else?
Yes, my lord. Yes.
You are hinting on that.
My lord. And our most important point at this stage, my lord,
we have the selection minutes.
yes,
Selection minutes are there.
Yeah, Lord.
The final declaration may be by somebody else, but the minute which has been prepared will stand.
I understand.
If APC are part of the selection committee, they have done the selection, but the final publication is done by Mr. P or X.
Right.
It is the selection of APC which is only being published.
But there is an but my lord will be effectively correct, my lord. But if
that we'll have to verify from the record.
But if the final list comprises of gradation of marks, suppose against all the categories, it is shown that marks have been allotted in such and such manner, and that list has been signed by 3 other members. That is the point I'm hitting upon.
Yes, please elaborate.
Yes. So that is not of today, my lord. I saw that from the records, my lord. It was produced earlier. The final selection list.
So we'll have verified.
Yes, my lord. That is number one.
What are your points?
Number 1 point. Number 2 point, my lord. My important for me, my lord, it is very crucial, my lord. From the affidavit filed by respondent 4, my lord, it appears that she has far more experience than the petitioner. To be fair enough, my lord, we are not challenging. We are. It would be of no interest. It would be of no interest to the petitioner to challenge her appointment, the appointment of respondent 4, because in her affidavit she has clearly stated her experience. She has altogether 15 years of working experience.
Yes.
So under that category, my lord, the category of there are 2 categories principally, my lord. We have educational qualification, other criterion, all are equal, my lord. Only difference is with regard to educational qualification and experience. Just these 2 headings, my lord. Against these 2 headings, my lord, we have no grievance against respondent number 4, because she is far more meritorious than the petitioner.
Yes.
But the simple my lord, the case upon which, my lord, the case, our case is at this stage is with regard to open qualification. Respondent number 3. Now, he has no experience as well as educational qualification. But from the records, my lord, it will be clear that he has been allotted more marks than the petitioner against these two heads. Just
Has no experience in education qualification.
and experience compared to the petition.
Then the petition.
Than the petitioner. So now what happened, my lord, in the final list of 2017, there, my lord will find that the respondent number 3 has been allotted more marks than the petitioner. Now, if those marks are, my lord,
How much marks have been given to
my
respondent?
lord, it was a difference in the experience. I think it was a difference of 1 mark, and in experience it was difference of 2 marks. So if this
In experience,
1 mark and
education and qualification.
educational qualification, it was additional qualification, it was 2 marks. So if these 3 marks are equalized, my lord, this is the petitioner, then petitioner ranking goes
How
down.
much is your mark?
Marks
What is the mark you have obtained?
I forgot, my lord.
What is the mark you have obtained?
I mean, there was a difference of 3 marks.
No, no.
If I remember-
How much? What is the mark you have obtained? You have not made any
petitioner,
RTA.
I think petitioner 77 and am I correct, my friend? Petitioner got 77 and respondent number 380. There was a difference of 3 marks.
The OBC candidate lordship, the post of exile Priyasuri, he secured total 77 marks, and Upen Kolita secured 80 marks. And
3 marks.
the Dr. Nilaki Chaudhary was the respondent, he also got 77 marks.
Nilaki Chaudhary, my lord, lordship may leave her. My humble prayer, my lord.
Priyasuri.
Three. The problem is with Priyasuri.
My lord, only Priya Sharif. So Samhita, lordship may, my prayer would be, my lord, lordship may only confine, we will confine ourselves only to the post of Priya Sharif now,
Okay.
because respondent 4 is better.
More
My lord,
experience.
So this is my precise, my lord, argument that if against these two heads, if these 3 marks are equalized, then the petitioner gets more weight, more marks than the respondent number 3, and so therefore his selection has to be considered for the post of lecturer in Priya Sharif.
Experience, you said 1 mark. Experience 1 mark.
My lord, in the rules, it is given.
No, you had said experience 1 mark has been allotted to the respondent number 3.
No, experience, I think 3 marks. And additional qualification, 2 marks.
5 marks difference.
No, petitioner has also been allotted, but the difference between petitioner and respondent number 3 is 3 marks.
Okay. He was given experience 3 marks. And education additional qualification
2 marks.
2 marks.
And petitioner
And the difference between you and the respondent number 3 is 3.
2 loss.
Huh?
Lordship, petitioner secured 2 marks in column experience,
No,
And-
total mark.
total 3. Experience,
Total mark obtained.
total 3 marks.
No. How much marks total did the petitioner obtain?
The petitioner 77 lordship.
No, petitioner got 77. And R3,
Party Upen Kolita 80 lordship.
80. 3 marks difference.
3 marks difference.
So he says that if this
Additional qualification and experience.
that is 3 plus 2,
My lord,
that is 5.
5.
If 5 goes, then you
Yes.
stand at a better footing.
I gain an advantage so far as selection for the post of lecturer in Priya Sharif is concerned.
Okay.
Now, rest, they have to consider, my lord. That is my,
That is all.
that-
See, he is abandoning the challenge so far as
respondent 4 is concerned.
respondent-
Nilakshi,
Mr. Goswami doesn't have to say anything.
his presence is
My lord.
required, my lord.
I'm not required to say anything, but
Your presence
but,
has made all the difference.
but in,
Yes,
but
ma'am.
in
Yes,
order
yes,
to assist-
definitely, definitely.
But in order to
Definitely.
assist my lord, one paragraph, my lord may, I'm not objecting him since he has given me the green signal, but I have filed one affidavit in opposition.
Now, we'll hear you after if we think it's necessary.
My-
First, let us see
My-
how the markings have been given to respondent 3.
Yes,
Because your the challenge against you, he has almost abandoned it. So there is no point going to that respect. Mr. Doctor?
Lordship, in this case, Lordship, multiple member interview are constituted with one member from the APSC and one subject expert. Subject expert award grading and which is ultimately converted to marks. And the members were allotted 30 marks under column general weight. And rest mark Lordship, it is I am just total allotted mark was interview for 100%. Out of which Lordship, 10 mark, 10 mark for SSLC, 8 mark for SSLC,
HSLC what?
HSLC 10 mark,
Till 10. Yeah.
HSLC 8,
Higher secondary 8.
degree 12,
Degree
degree Lordship,
12.
and postgraduate degree 15,
15.
and experience 3,
3.
additional qualification, including Lordship seminar, publication, conference, is true Lordship.
Yes.
General bearing 30,
General
bearing 30 Lordship, and knowledge of the subject. Lordship, mark under SSLC
knowledge of subject is how much?
20 Lordship.
That is this 50 is interview part. 30
Interview
plus
part.
20.
Interview part. That's
The-
30 marks for member and 20 marks for the subject expert. Knowledge in the subject. And Lordship, mark under SSLC to postgraduate degree, it is based on the document submitted by market testimonial. And the
Just a minute, just a
additional
minute. Just a minute. That means you have given 50 for objective on objective standard
on the testimonial.
and 50 on the basis of viva voce, where 30 is given for general bearing
Lordship,
and 20 on the subject expert. Okay. Yes. Now, how do you make his argument?
Lordship, in this case, Lordship,
He
on the-
says that response number 3 was not equipped with any experience.
Lordship,
In spite of that, 3 marks have been given. Number 1. He also contends that there is no additional qualification for which 2 marks have been erroneously given. So if you deduct this 3 plus 2, 5 marks, his mark will be less than the addition. That's the
Lordship, I have that mark sheet. In the mark sheet, Lordship, there is a column in a remark column. I will Lordship first. And there is what is the qualification has been Lordship written in the last column, Lordship, column number 14, remark column. And on the basis of that, response number open filter was awarded 3 marks for experience, and under heading additional qualification was awarded 2 lots. Ultimate general bearing he was awarded 26, and subject knowledge he was awarded 16. Total 80 marks secured. Okay,
no. Mr. Paul is not making any challenge with regard to the marks given in the viva voce.
okay.
He is only saying that experience and additional qualification 5 marks, which can be objectively assessed, are wrongly given.
Only
Okay.
five marks.
Experience mark was allotted on the
On the
basis
basis
of
of what?
the certificate produced by the candidate. But here, in my record, no certificate is available because all the certificates were forwarded to the
No, that
government
is
law.
okay. We only he is making a categorical statement that there is no testimony to give marks of experience and additional qualification. We just want to have a look at those.
Lordship, in order to get that information, Lordship, we'll have to call for the record from the department, Lordship. Because after
Department is
recommendation,
there. for us.
all original testimonial has been forwarded to the department
My lord. In this
for their
case,
further verification.
my lord, I appreciate my learned friend's judgment, but from the affidavit response number 3,
Yes.
he appeared that he was under my lord, he misunderstood. From the affidavit clear, he misunderstood that additional experience and additional qualification and experience is required for the post. I will just
No, in the affidavit, how has he responded to your averment?
yes.
By the response of 3?
Yes, my lordship is very correct. I will just take your lordship to the relevant paragraph. My lord, paragraph, first of all, my lord, paragraph 5. Paragraph 5, page 2, at the bottom. last paragraph.
Hmm.
I will just produce, show, my lord, that the averments made in paragraph 3 in the petition is irrelevant since the petitioner has furnished his biodata with the application as it was not asked to furnish it. Now, my lord, as it was not asked to furnish document or extracurricular activities other than basic qualification, this is clearly a misconception, my lord, on the part of respondent 3. Because my lord has seen from page 15, my lord, that wherever additional qualification is there, you can annex it. Now, he has not annexed. Then again, paragraph 9, my lord. Sorry, I'm sorry. Page 3, my lord, it continues.
Now, first, let us see your averment regarding the response number 3.
Yes,
Not meeting.
definitely. I appreciate, my lord. I appreciate your lord's query. I will take your lordship specifically to the paragraph where I have stated. My lord, that paragraph, my lord, paragraph 3. Paragraph 3. Paragraph 3, my lord, I have given my general biodata, and I have also stated in paragraph 5. Paragraph 5. Paragraph 5.
No, not 5.
No,
You come to
no.
paragraph 8. Paragraph 8.
I'm sorry. Yes. My lord, I'm very grateful to your lordship. The petition is far more meritorious than respondent 3 and 4. This will be borne out from the biodata of the petitioner as well as respondent 3 and 4, all of which form part of the request of the selection.
Come to 9.
The petitioner begs to state that insofar as marks allotted under the heading academic record, the petitioner is likely to secure more marks than respondent 3 under subheading degrees concerned. In respect of research performance, the petitioner has number of research papers, article publication to his credit. He has also presented papers in seminar, but the respondent 3 does not have any publication of articles, research papers. Therefore, under these heads also, the petitioner is likely to secure more marks. Now, my lord, so my lord, relevant paragraphs.
How is it paragraph 9 been applied to?
Been countered? Yes. I follow. Paragraph 9.
You come to paragraph 10.
10. That in regards to paragraph number 9, the opponent states that petitioner filed on a probability as stated, underscore, the petitioner is likely to secure more marks than respondent 3. Inverted comma close, not carry any legal value as the selection body is empowered to decide the factors of selection. So, my lord, from these averments, my lord, I would like to submit before your lordship that the respondent 3 was, my lord, he was maybe misguided, my lord, regarding annexation of documents so far as additional qualification and experiences.
How was this mark given of 3 and 1 when he said that he is not making any claim himself?
Lordship, in this regard, lordship permit, I will draw your lordship attention in another aspect. In the advertisement page 14, lordship.
Advertisement, what is that?
Page 13, lord. 13.
Yes,
13.
Yes.
Lordship, page 14 is 11.
Yes.
The education qualification, lordship. A degree in Ayurveda from the university established by law, or a statutory body so medicine or equivalent so under Medical Council Act.
Correct.
A postgraduate qualification in the subject, especially included in the schedule in the Indian Medical Council Act so candidates should be registered so. But in the advertisement, there is no prescription for education experience. The lordship has decided one case, lordship Shankarnath.
Then why have you given mark?
That's why I'm pointing out. It is my duty to point it out, lordship. It was interview was done in
If it was not a part of the scheme of giving marks,
yes, lordship.
why have you given mark?
Yes, sir. The rule is that, lordship, when there is service, there is no provision for experience, and the advertisement is also silent. No candidate is entitled for any mark.
How much marks he has been given? The petitioner.
Petitioner 2 plus 1, lordship. 2 for experience and 1 for additional qualification.
3 and his 5 will go.
Lordship.
If you remove 7. Mr. Pal,
my lord,
even if we assume that these marks were given or rather unwarranted, there is no scope to give these marks. So 3 plus 2, 5 may go away from the response number 3. But the marks given to you under these heads will also have to go.
I will check, my lord. Just 1 second, my lord.
If it is not, if it cannot be given to A, it cannot be given to B also.
Then the entire that merit list,
74.
lordship, which I have placed before your lordship,
Yes,
will have to
there will be difference of 1 mark.
Then
Lordship is correct.
difference of
74
one will be 74 and 80,
and he-
85.
75. Yes,
75.
Lordship is correct. There will be difference of 1 mark.
Still one.
My lord, response number 3 will gain 1 mark.
1 mark.
1 mark. Yeah. Lordship is correct. But my lord, the troubling factor is there. Uh, uh, in the head against which they have allotted mark, HSLC, beginning from HSLC to subject expert.
Right.
My lord, they themselves have admitted that for additional qualification there is 2 marks maximum, and for experience there is 3 marks. APSC has they have just now my learned friend is submitted.
No, if he has fairly submitted that the prescription laid down in the advertisement, it does not even contemplate of giving of marks.
Just
And
yeah,
why we are saying that
yeah,
if you have already drawn the attention of this court to page 15
yes, yes, yes.
and C,
See,
this is a very general requirement.
Yes.
And therefore,
my lord,
in experience certificate, it is within bracket where necessary.
where necessary, where necessary.
Here, there was no necessity of an
Directly
experience certificate. If they have said that for experience you get some marks, then the matters are different. The advertisement does not say anything. If the advertisement does not say anything, then giving marks on certain heads, if nobody is challenged, then matter is different. Uniformly, everybody is given. Now it's a matter of challenge. And if we remove this, then the difference is still there.
I understand. I follow, Lord. I am absolutely with you, Lord.
Under those circumstances, whether you can, we wanted to so you wanted to hear a response number 3. Why is it not? Why isn't it appearing? What is his name? Who is found?
Earlier efficiency appeared, my lord. Today, my lord, I don't know.
PK does it.
And my lord,
PK does it.
Yes.
Railway Council.
is
I appeared for the first time in this case.
PK does it. Railway Council.
and P does. Miss P does.
Normally, is there.
Yes, he is a regular. He's very regular, my lord.
Vimal Kumar. Who is Vimal Kumar? Not Vipul Kumar.
I-
It's Vimal Kumar.
Mine.
Vimal Kumar does it. How much is the difference of your marks and response number 4?
My mark.
Your marks is that
Yeah, my it is 77, my lord, and response number 4 is
no response number 4. R4,
R4 Dr.
not 3. R4.
yes, my lord.
Dr.
Yes.
Nilakhi.
My lord,
Dr.
What is his
Dr.
name?
Nilakhi Dev Chaudhary,
77.
my lord. 77 petition.
What is your name?
My name is Dr. Amit Sarnakar, petitioner.
Below than Dr.
And Dev Chaudhary is R4.
R4.
R4 also got 77. Oh, no, this is not for Kriya Sharif. We are on the different.
What the other Samhita, Siddhanta Samhita and Sanskrit. The second department, my lord.
Here
How much in that
Kriya Sharif.
subject? How much was the mark
the 88 secured by Nilakhi Dev Chaudhary lordship,
and petitioner?
and the petitioner lordship he secured 79, Lord.
88 and 79, even that marks are quite different.
Yes,
Even
almost,
if we remove the experience part.
Lordship.
yes.
And
We-
there is only difference only 1 mark, Lord. Experience, elected deputy secured 3 and petitioner secured 2 marks, Lord. And additional qualification both secured 2 marks. So only 1 mark difference.
No, even if we assume that or accept this contention that these has not prescribed, so no marks can be given. So his marks will also have to be erased. In that case, also Nilakshi stands on a much better footing.
Better mark.
Yes,
The difference is how much?
Only 1 mark, both.
No, total marks. 88 and
88 and 79, Lord.
88 and 79.
79.
9 marks difference.
9 mark difference.
even if we deduct those two categories, my lord, it will be how much?
79 and 88.
The 9 is the difference.
Nine is the-
But he still the
Oh,
difference.
there is total 5. I
difference will
understand.
still be 8. I think.
Total is 5, my lord. Yes. Still 4 marks.
And what about your other? What is the other?
Other grounds, my lord.
Other grounds of
Yes, yes, I will come to that.
the committee change
Yes,
in the
I-
committee. What is that? Mr. Dutta, what was that?
Lordship, that committee was not, selection committee was not constituted as per UC. But Lordship, this case, Lordship, was constituted under the FPSC regulation 2010, Lordship.
Paragraph 12 of the restriction.
Lordship, it is chapter 3, Lordship, direct recruitment. Chapter 3, direct recruitment. The 21, Lordship, clause 21, the chairperson shall constitute board or interview viva voces for candidate for various posts which selection is to made. Single member or multiple member board may
Paragraph?
paragraph 21 Lordship clause. I am reading now. Lordship got it?
Yes.
1. The chairman shall constitute board for interview and viva voce test of candidates for various posts for which selection is to be made. 2. Single member or multiple member board may be constituted, taking into the consideration of grade, status, and importance of the post in respect of which the selection is to be made. Ordinarily, a single board, either with a single member or a multiple member, will be constituted for selection of a particular post or post. But where the number of candidates is large, it is not relevant. Where more than one multiple member board are considered, a constitution of board may be changed by rotation. The methodology of awarding marks under appropriate head shall be adopted by the commission, taking into consideration of status grade. The program now, Lordship,
Yes.
Clause 29, Lord.
29.
29, Lord. The commission may determine the qualification standard by giving weightage on academic merit, subject knowledge, additional relevant qualification, service experience relevant to the post. Important is just relevant to the post. For preparing the final order of selected. In the viva voce test, marks shall be allotted as below: 50% on academic, professional qualification, service experience relevant to the post preferential qualification, and 50% for subject knowledge and general bearing. Out of this, 20% shall be the subject knowledge and remaining 30% for general bearing. And the general and there shall be 5 grading for advisor or expert mark. That is excellent, very good, good, fair, and average. The value of which shall be determined by the commission. The commission recommended. The
But
commission,
in that case, where the marks which were granted to the response number 3
Lordship,
under this particular head, was there any supporting document?
Lordship, now Lordship, it is, I cannot say, but what is our procedural follow? At the time of application, Lordship, candidate has to submit their experience certificate or additional qualification certificate. That was scrutinized by the officials. And if there is something, there is a statement has been prepared. And after selection, all that original application and the supporting document were sent to the government. Now, until and unless that statement copy available and the original record from the government, there must be Lordship supporting document. Some cases, Lordship, though I have to say, without supporting document in idea, there are instances of granting mark loss during the regime of then take this.
My lord, I would again like to
Nilakshi Dev Chaudhary is response number
4.
4.
My lord.
And your name, Upen Kolita.
No, my lord. I am Dr. Amit Sandakar and petitioner is
Upen Kolita is R4. R3.
my lord. My lord.
R3 is Upen Kolita.
Correct. Yes, yes, yes.
And R4?
R4 is Nilakshi, Dr. Nilakshi Rajputri.
And your name?
I am Dr. Amit Sandakar. My lord. My lord, just now, what is fallen from my learned friend's mouth regarding Rule 29, if I may be allowed to repeat, my lord, the same submission, that the same point, my lord, additional qualification and experience. In the rules also, they find reflection in Rule 29. So, I possibly it cannot be ignored, my humble submission, Lord. Lordship may consider it or may reject it, but my fair.
But unless a candidate is made aware
Oh, yes, yes.
on the
Then,
prescription of how the marks should be, how the evaluation will be done.
No, that is
Our candidate who is not required to furnish documents which are not mentioned in the advertisement.
I agree, Lord. I agree. But it is why
Now, if you say that experience, there is no mark mentioned in the advertisement, or it's not on the based on any experience, so you did not put any experience. If you put, it's a different matter.
I follow, my lord. That is why the presence of responsibility probably is required, or my lord, the records from the government would be, my lord, would be.
But is your client really interested in this?
Yes, my lord. He has been waiting very patient, anxiously, my lord. In the meantime, he has lost his parents also. That is not, of course.
Yes, when we want to have a look at the records.
Government.
Madam, you can. Oh, this is the
health department.
Health department.
Yes, yes.
We just want to have a look at the records as to how we have given marks under the heading of experience and additional qualification. Even the petitioner has got that mark and he is questioning the mark on these two heads given to the private respondent. One respondent he has almost abandoned because there are documents to that. But so far as one number 3 is concerned, he is making a serious contention that in spite of the fact that there was no experience or education qualification, marks have been annotated. And why we are asking you, normally we would have closed in the affidavit by the respondent number 3, he has not disputed this. Rather, he has said that he was not even aware. Meaning thereby that he had not given any certificate. If certificates were not there, how marks were? When can we have this, madam? The whole matter.
Earlier requested, my lord, health long.
Next Tuesday, can you have
Yes.
the record?
My lord, on an earlier occasion, my lord, learned counsel, sending counsel to the health department submitted before the honorable court that records are ready with him, but that was in the year 2019. So in the meantime,
And on Tuesday, is it possible on Tuesday?
Miss R declared here.
Doesn't matter who has made up. Can you produce on Tuesday next? Is it possible? We'll have it on Tuesday, the part.
Yes, yes, madam. Yes, madam.
Or the A part, and it counts for the petition. Also heard D for MSD for Training Council, Health and Family Welfare Department, comma. The PP Datta,
That's one number 2, Lord.
Learned Training Council APS. The SS Gustami, Learned Council, is present for the response number 4. So the names of the Learned Council for the response number appear in first comma. None is present. The matter has been heard at some time. Do read doctor, the understanding of the APS has produced certain documents pertaining to assessment of marks from the state documents only consist of evaluation sheet and the documents based on which the assessment has been made are stated with the department. Since a particular, since a categorical submission is made that marks allowed to the responsible 3 under the head of experience and additional qualifications are without any basis, this could but have a look at the record. More particularly, the documents of this one which were taken into consideration for assessment. This case now Ms. Bora did understanding of this for some time to obtain record as wait for some of this for order here on Tuesday next.
My lord, the order which I mentioned, that is dated 25/7/2019.
Which order?
My lord, where Senior Counsel for the Health Department submitted that the records are
Okay, doesn't matter.
yes, 25/7/19.
You can say it.
Maybe it is in the still lying with the understanding counsel. I don't know, my lord. Maybe he has written back also. Deeply obliged.
Mr. P.S. Bhattacharya has not come. Mr. Dhar, your colleague, Mr. Bhattacharya, P.S. Bhattacharya, we wanted to have completed partner matter. What is this matter?
This is promotion.
Item number
7.
has got a where is
My lord, S. Bothagur is not in Guwahati, madam. He is out of station, madam.
to come up and say
My lord, we do not have the instruction to obtain, we did not obtain their consent during the morning hours.
When the matter called upon, okay, we'll fix it another. Food has been informed. That's what. Petitioner is out of. We go subject. Can you take it up for discussion?
My lord, yes, please.
So, what is the that the matter can take up? This for
Deeply obliged, ma'am.
My lord, this is the matter when the Panchayat PDP president and secretary were elected. Though I was selected by the village people, or selected me, but illegally, the SPO appointed the respondent number 5 as secretary of VDP of this place. That is why, my lord, they have filed affidavit. They have also admitted that Durgamari VDP secretary in the district of Bongaigaon. The SP has filed affidavit. He has said that.
who makes the appointment?
My lord,
Who makes the appointment? Appointment is made by whom?
by SP.
By the SP.
Yes, that order, lordship may kindly see, page 29.
What are your grounds of challenge? What are your grounds of challenge?
Ground of challenge, there were 208 persons in my favor. Only 11 persons were against me. Public adopted me as the secretary, and that was forwarded to police station. Police also selected me. OC also, I
Yes,
think
so what's the reason?
SP has also filed affidavit that I stood first and people selected me. So that was actually hiddenly, there is some political pressure perhaps.
Nothing of that sort. The lordship is a tenure-based post for 5 years. After 5 years completion, a new village defense party is reconstituted in terms of the act, and it was constituted, and the meeting was held, and 2 people were to the private respondent of 5 and the petitioner. There was basically a dichotomy situation as to whom to choose. Ultimately, private respondent of 5 was.
No, he said that the majority of the people wanted.
That is what on last occasion the minutes of
Already
the meeting.
reiterated in our orders.
Minutes of the meeting dated 22/2/2022 was cited to be filed, and we have filed it. And as for the minute, your lordship may kindly go to the ethical affidavit. That was the only issue as to on what basis that person was the private respondent of 5 was selected.
No, the submission which Mr. Mahmood is making, that the majority wanted him number 1.
No.
The police was in his favor, and with the SP says that
No.
that was for the earlier selection of.
No. For this election, not for his case, it was not the case as he is trying to project. In this particular case, the police has actually the Thana level, or he's the Thana level village defense officer. So he recommended the name of the private respondent of 5, and on that basis of the recommendation only, he was appointed. And we have annexed that.
R5 has been
public-
served or not?
No, my lord. No, 5 is justice service was taken, and that was he refused. He said the SP will protect my interest.
Okay.
My learned friend is saying something which is beyond his own record.
No.
Can you say best 5-0?
Can you take this for disposal?
Yes, that was fixed for that purpose. Your lordship also acted on that may remind me. Kindly say was 50 of the SP's affidavit. Yes, 50. SP's second additional affidavit. It was filed on 28/2/2023.
Let us have the basic facts.
My lord, fact is this, my lord, after 85 years, PDP secretaries are selected by village level committee. So some
The
persons,
tenure of VDP secretary is 5 years.
5 years. But after that, some persons are even working since 45 years. I have brought all these things on record by filing affidavit. So that is not my case, sir. So after 5 years, I also became one of the candidates and
You were,
private.
you were the earlier secretary.
First time I was, every people likes me. Only this 11 people, 11 or 7 people filed a petition before the
Commissioner was
MLA.
the earlier secretary.
First worship can you say affidavit.
No, when was selection held?
Selection is that is why affidavit here said everything. It is 50.
No, from 2025 to 6/3/22, you have served. Petition has served earlier.
Yes.
Then the new, there was the occasion to have the new BDP.
Yes, and that people also selected me.
Okay, you are also a contender for the post of
Yes.
secretary.
Okay, everything will be clarified. Kindly see plus 50.
50.
SP's affidavit.
It's the additional affidavit.
Yes. Second
Affidavit is different.
additional affidavit that is also within record. First we have sent 50.
50 is a part of the affidavit.
Yes.
It starts at 48. Is it 29 July 2022?
Yes.
27 to dated 27 to 22.
20, not 27, 29, 7.
SP has 2 affidavits.
Now at page 48, one affidavit starts.
That's the additional.
Yes. Now, then Lordship kindly see S50 of that affidavit. S50.
50 is not.
50. That is the annexer A.
These are not mentioned.
Annexer A of that affidavit.
Are you referring to the additional affidavit?
Yes. Affidavit.
To
Yes.
second mark.
The second one, yes.
This page 62.
62. They have marked this. I don't know why they have. Now, kindly see annexer 1 of that affidavit.
By R2.
27 to 22. That's what I said.
Just a minute. Just a page. First affidavit for annexer A.
Annexer A.
Meeting.
Yes.
Yes.
Now, kindly see that is the agenda of the meeting. The bottom of that page, kindly see. Present in the meeting. That's what I said. Bottom.
Next page.
No, that is annexer A.
Yes, present in the meeting.
Yes. Present in the meeting, Mohammad Shahjahan Sheikh, Mohammad Zulfikar Ali, Mohammad Ashinu Sheikh, Mohammad Amjad Haq Sarkar and other proposed resolution of the All Durgamari Village Defence Party (VDP) has opined for the formation of a new Durgamari Village Defence Party. Also, the allegations against former secretary of Durgamari Village Defence Party has been proved as false. Some persons raised some allegations. It is found false. In fact, the former president of Durgamari VDP, Mohammad Jubatullah Sarkar, has alleged that his signature was falsely taken under the pretense of formation of a new village defense party. So that was the case. They took the shelter of forgery and took the signature of the president saying something else. That was the allegation, but it was found false. Now, Lordship, kindly see next page. Next page, para 4. For the post of president of the new VDP, one name has been recommended by the people present in the meeting. However, for the post of secretary, 2 names, namely Muhammad Naushad Ali and Pierre Ali, have been recommended by the people present in the meeting. The people present in the meeting, being unable to finally decide between the 2, has requested the concerned officer in charge of Vidyapur outpost, Sri Thogish Dole, to make the final selection between the 2 candidates, and has also stated to have no objection to the final selection made by him. It was also undertaken in the meeting that the decision of the IC of the police station will be accepted by the people present in the meeting. As such,
What is your name?
hello,
Your name?
My name is my lord Naushad Ali.
Namaskar.
As such, for the purpose, the OCIC after deliberation, as per the credibility between PR Ali and Naushad Ali, Mohammad Naushad Ali was selected as being more competent for the post of secretary, Durgamari VDP. Therefore, the new VDP committee has been constituted as under. Now, my learned friend has submitted beyond record.
No, Your Lordship.
No, we'll come to you.
Now, the people entrusted the matter to IC, Vidyavar Outpost and OC. Then they said that as such for that purpose, the OC and IC, OC means OC Bongaigaon, IC means IC Vidyavar Outpost. After deliberation as per the credibility between PR Ali and Naushad Ali, Mohammad Naushad Ali was selected as being more competent for the post of secretary, Durgamari VDP. Therefore, the new VDP committee has been reconstituted as under. President Azizul Haq, Secretary Mohammad Naushad Ali. So, this is a clear thing, my lord. So, there are some other posts. So, meetings, all the agendas have been also produced along with this annexure. Now, Lordship may kindly say this is the decision
I have just
and SP's first affidavit kindly. SP's first affidavit that was filed, I received on 22/7/22 in first affidavit.
Yes, sir.
Second page, para 5.
Filed on 29 July 22.
We have received it 22/7/22. Kindly see second page. Second page, para 5.
Yes.
As regards the statements made in paragraph number 3 of the writ petition, the answering deponent stated that it is fact that the petitioner rendered his service with utmost sincerity and satisfaction of superior authority as mentioned. So he has admitted, my service is satisfactory. So far rule is concerned, that is admitted. After 5 years, the new secretary shall be selected. Now, my learned friend says about 5 years. Let me show an affidavit. I have filed an affidavit. Lordship may kindly say, this is filed on 21/9/22.
Your affidavit.
Yes, my affidavit in reply. It is filed on 21/9/22.
Yes.
Kindly see, my lord, page 50. That is para 8. Para 8, I am reading, my lord. Para 8. In fact, that the reputation is a much more experienced and qualified to be appointed for the post of Secretary of Durgamari. VDP, even in the public meetings, people strongly supported his candidate for VDP Secretary, and he also was also the choice of local officers. The petitioner also had the support of 208 villagers at the time of appointment for the post of Secretary of Durgamari VDP, but only due to the recommendation of letter forwarded by the local MLA 32 number Bongaigaon LSC to the officer in charge of Bongaigaon Police Station, he was not appointed as secretary, which has caused serious sorrow. Now, kindly see, his satisfactory services have been also acknowledged after a few lines by SP in para 5 of his affidavit. Now, so far the 5 years are concerned, kindly see now para 9 well. The petitioner makes to say that although he has crossed the limit of 5 years as per Rule 19 of Assam Village Defense Organization serving as secretary, but that does not mean that he cannot be reappointed, as almost all the earlier appointed secretaries have held the post secretary for more than 5 years, and as the petitioner also has a very excellent service record.
Okay, we have.
So I have given
got
the
it.
list. My lord, kindly see the list, page annexure 1. Here, some person, Lordship would see, some persons here, Longdoba VDP Secretary Abdul Barik, he is working since last 40 years, madam. Now, last Ghilazari Part 1, that is Subhan Ali, he is working 45 years. So, in this manner, my lord, up to 45 years, this is I am on record, my lord. So there is no bar. Actually, everything depends on the people. Now, only few persons submitted petition against me. I am also submitting that, my lord.
Where is the impugned order?
Impugned order, Lordship may kindly see page 29.
29.
Yes, of the writ petition.
Yes.
It is by SP. The approval order of new committee, the following new committees of BDP under Bongaigaon PS have been reconstituted and approved with effect from 6/4/22 with the following new official. Durgamari BDP President Azizul Haq, Secretary PR Relation. No reason why the public's recommendations were not accepted. No reason. Now, so far, Lordship kindly see, 208 people supported me and only 11 persons were against me, my lord. That may be seen page 30.
Is 30.
Page 30.
Yes.
Here, the letter has been written to the SP by people, and among those people, my lord, so many earlier persons and leading persons of society. Here, my lord, altogether 208 persons have supported me, and only a few persons that let me show that is also here. And my lord, another matter is this: I have passed higher secondary examination, and the other party has no formal education at all. So, my lord may kindly see page 13 onwards.
Page?
1-3. This is my higher secondary pass examination, pass certificate. That then kindly see page 16. It is Red Cross, Indian Red Cross Society. So they have also acknowledged my sincere services. Then night patrolling, well, I have also done tremendous job in respect of some terrorist persons who wanted to derail the peace in the society. So those things are also the para 17. I have submitted the list of certain persons, that these persons are doubtful persons.
Okay. Doesn't matter.
So, my lord, everything is in my favor, man. And this.
Okay. I think we have. Yes. Why have been responded to?
Lordship, if your lordship may kindly peruse to the additional affidavit as my learned senior was actually pointing out.
Additional
affidavit, the minutes of the meeting. The decision as to who would be the secretary was left upon the OC of Banga Police.
He has
selected that particular decision. Here, page number next, just after one page. He had written to the superintendent of police because the decision was left up to him by that particular meeting. The minutes of the annex to the letter.
Yes,
our page is somewhat different, but anyways,
I to the under will be accepted as such paper.
To the superintendent,
was selected. No.
To the full superintendent of police, just after the last page of that minute, one page, just after one page, one handwritten letter to the superintendent of police. That is from the OC CVTO Pavdo. That is the Thana level village defense organization officer to the superintendent of police. Prayer for approval of the reconstitution of executive committee of registered BTPs and the Bongaigaon police station. That particular letter. With reference to
we don't find part of the additional affidavit.
It's an additional affidavit.
Additional affidavit. Internal page, which page?
Internal page 53.
No, of the additional affidavit. It's handwritten.
Handwritten.
Yes.
To the superintendent of police.
Yes.
So this was written by the Banga Police Station OC to the SP, recommending for Durgamari VDP, that is the petitioner's
What the Durgamari?
Durgamari VDP, Village Defense Party. So, in terms of the minutes of that particular VTP of the president, Durgamani Village Proceedings Committee, the new committee constituted of Azizul Haq, which is the president within brackets P, PR Ali Sarkar, secretary, which is a private responder of 5.
Yes.
And the third is Abdul Munaf Sheikh.
Yes.
And the whole committee consists of that petitioner number 2, petitioner at serial number 2, Naushad Ali, as secretary. So based on this recommendation only of the
What is the basis of recommendation? We want to know that.
So we have stated that in an affidavit, Your Lord.
But what is
In an affidavit, we have stated. I would like to take your lordship to the affidavit at page number 3, paragraph number 7. That is regards the statements made in paragraph number 5 of the writ petition answering deponent states that the officer in charge
of this additional affidavit?
No, of
Main
our counter affidavit.
The counter affidavit. Okay.
Paragraph number 7.
Paragraph 7. Yes.
That is regards the statements made in paragraph 5 of the writ petition answering deponent states that the officer in charge, Rohanga Police Station, come Thana level village defense officer, had received a public complaint from one Mobatullah Sarkar and 10 others, all members of Durgamari VTP, dated 8/1/2022, stating inter alia that they are deciding to resign from the post as member as they are witnessing large scale of anomalies from the secretary and petitioner Naushad Ali. The same petition was forwarded to the officer in charge, come Thana level village defense officer by the Honorable MLA Sri Fanibhushan Chaudhary of Banga constituency. Thereafter, officer in charge, Banga Police Station, come Thana level village defense officer, had asked the circle officer organizer of video to inquire and report. The CO video submitted his observation to the officer in charge, come Thana level village defense officer of the Banga Police Station. Then the matter was referred to a district village defense officer and SP Banga for perusal. The undersigned directed since this has been filed by the SP, the COVIDO to call for a public meeting to find out the actual facts about a complaint petition. Accordingly, a public meeting in Durgamari dated 27/2/2022 under the presidency of the Ramkrishna Bodwa, President Thana level committee. In the meeting, the President Sri Mobatullah Sarkar resigned from his post along with Naik Messer, Kaka Sarkar and other members of the Durgamari VTP. Thereafter, a meeting decided to recommend 2 names, namely Naushad Ali petitioner and Mohammed PR Ali for the post of Secretary Durgamari VTP. The minutes of the meeting with the recommendation from COVDO and officer in charge has been received and perused. Based on the recommendation after considering the tenure of the present committee, the deponent in the capacity of CVDO approved the name of new president Azizul Haq, Naik Mohammed Munaf Ali and Secretary Mohammed PR Ali for Durgamari VTP. The deponent exercised the powers vested under provision of Rule 19 of the Village Defense Organization Rules 1986, where it is stated that the tenure of all committees formed under this rule shall be for a period of 5 years from the date of formation of each committee. On expiry of the terms, each committee shall be reconstituted as provided herein before. The whole committee, however, shall continue to function till a new committee is formed. Since the present committee has crossed the period of 6 years, therefore, the undersigned taking into consideration of time period and the recommendations decided to choose Mohammed PR Ali as secondary from names suggested by the villagers in the meeting held on 20. Thus, the allegation level in para 5 is not based on merit or not name.
What is this rules of 1986?
5 years term.
Is there any bar in re-election?
It's not an election based, it's not a vote based system.
Is there any bar in re-appointment?
There's no bar as such. There's no bar.
Because in the chart, yes, shown, the certain secretaries are going for 40 years.
In my humble submission, Your Lordship, there can be no negative equality in this respect because some people might have.
No, negative equality, there has to be a bar. It's not a question of negative equality. Your reason to appoint the respondent of 5 for the petitioner, it has to be backed by certain cogent reasons. Where are the reasons?
In my humble submission, that is the para number 7.
It appears that it's on the whims of SP. or use. Well, how do you overcome the minutes of the meeting?
Basically,
When
the
the allegations have been held to be incorrect, you take an unanimous decision to have him as the VDP. In spite of that, the letter comes on 30/3/2022. Why?
basically the decision was left in terms of the meeting held on 27 to 2022.
Where we have not seen.
If your lordship proposes to
Come
the
to the
minute
meeting. Come to the meeting.
meeting again, your lordship. Last, I will start from, it was also undertaking.
64.
It,
Yes.
it was
For
also
the post.
for the post of
Yes.
EDO, secretary.
Yes, for the post of the president. Last
For the
paragraph.
post of last paragraph.
One name has been recommended by the people present in the meeting.
Yes.
However, the post of secretary, two names, namely so and so, have been recommended by the people.
Yes.
The people present in the meeting, being unable to finally decide between the two, has requested that the concerned OC so and so to make the final decision between two candidates and has stated to have no objection to final decision. It is
Yes.
also undertaken in the meeting that decision to so and so will be accepted to be as such. For that purpose, the OC and IC, after deliberation as per credibility between so and so, Sri Nosad Ali has been selected to be more competent.
Your lordship,
How do you overcome this?
somehow it is contradictory. I mean, my humble submission.
If
Because
in the meeting he takes a stand
yes,
that
that
it's
is
left to
contradictory.
me, I think that the petitioner is more competent.
That
Now
is contradictory.
he changes his stand in the letter. Right.
Because again, like if this is a translated version,
Let us see the
original also I could not make out the handwriting actually.
let us see the original.
Original is at page number, again, it is page number 64.
No, no. The, I think it be we not know. Your page it be 56 maybe.
If your lordship,
I can read. Please give me, I will read.
Abhapati, that page 56.
yes, Bhavati
I
Raizor,
can read. সভাপতি ৰাইজৰ মতামত অনুসৰি দুৰ্গামাৰী ভিডিপিত নতুন কমিটিৰ ক্ষেত্ৰত সভাপতি আৰু সম্পাদকৰ পদত একজনক প্ৰাৰ্থী মনোনীত কৰে যে যদিও সম্পাদকৰ পদত মহম্মদ নৌশাদ আলী আৰু মহম্মদ পিয়াৰ আলী দুয়োকে ৰাইজে দাবী জনায়। সভাত ৰাইজে এই দুজনৰ এজনকো চূড়ান্ত সিদ্ধান্ত কৰিব নোৱাৰি মাননীয় বিদ্যাপুৰ অপিৰ ভাৰপ্ৰাপ্ত বিষয়া শ্ৰীযুত ঠগীশ দলে মহোদয়ক দুজন প্ৰাৰ্থীৰ যিকোনো এজনক বাছনি কৰিবলৈ অনুৰোধ জনায় আৰু কোনো আপত্তি নকৰে বুলিও ৰাইজে সভাত জনায়। থানাৰ OC আৰু ICয়ে মহোদয়ৰ সিদ্ধান্তক ৰাইজে গ্ৰহণ কৰিব বুলিও সভাত সিদ্ধান্ত লয়। সেই উদ্দেশ্যে বঙাইগাঁও থানাৰ OC, IC আৰু CRDBTৰ আলোচনা মৰ্মে গুণগত মানৰ ভিত্তিত মহম্মদ পিয়াৰ আলী আৰু মহম্মদ নৌশাদ আলীৰ মাজত মহম্মদ নৌশাদ আলীক সম্পাদক পদলৈৰ বাবে অধিক উপযুক্ত বুলি প্ৰমাণিত কৰা হয়। সেয়ে তলত দিয়া ধৰণে দুৰ্গামাৰী ভিডিপি পুনৰ গঠন কৰা হয়। দুৰ্গামাৰী গাঁও সভাপতি আজিজুল হক সভাপতি, সম্পাদক নৌশাদ আলী।
And even if there is any ambiguity in understanding,
Same thing in it.
the following the formation of the VDP itself makes it abundantly clear that the decision was taken in favor of the petition.
And the allegations are found false. That is also there in the SP's affidavit.
Heard. Mahmood that sounds for the petition. Also heard. P. Bora. And it state council. In its last order, the court has also recorded that the service upon the response number 5 was deemed to be complete as he had refused to accept notice of this case, and in that regard an affidavit has also been filed. The present challenge made is with regard to filling up of the post of secretary of Durgamari Village Defense Party in district of Bongaigaon. The case of the petitioner that he was the earlier secretary for the tenure 2000 for the tenure from 25,016 to 6/3/2020. After completion of the term of the VDP, which is 5 years from the state VDP, was required to be reconstituted. The petitioner and the respondent number 5 were contended for the post of the secretary. The a general meeting was held on 27/2/2022 in the presence of the concerned persons, including the officer in charge, including the officer in charge of the Vidyapur outpost as an officer in charge,
Officer is Bongaigaon Police Station
including the
and in
including the
Vidyapur
in charge of Vidyapur outpost and the OC of Bongaigaon PS. In the state meeting, it was resolved that though there were certain allegations against the petition, the same were found to be false, and the meeting had ultimately left the decision to be taken by the OC and IC of the concerned police station and outpost. The state two officers, after deliberation and considering the credibility of the two candidates, had selected the petition as the secretary of the state VDP, and according to the VDP was constituted with the petition as its secretary. The grievance of the petitioner is, however, with regard to regard to
That's 29.
regard to an order dated regard to a communication date 7/4/2022 issued by the Superintendent of Police Bongaigaon of constitution of various VDPs under the Bongaigaon PS, and so far as Durgamari VDP was concerned, the respondent number 5 has been shown to be the secretary. Sri Mahmood Talar, counsel for the petitioner, has submitted that there are no reasons for ignoring the claim of the petitioner, and also to take a contrary stand after the general meeting has selected the petitioner for the state post. It is further submitted that in state meeting, the officials of the concerned Thana were there who had taken into account the credentials of the two candidates and had come to a final to select the petition. And that decision was not the matter of any child. He accordingly submits that the impute order, the impute communication, so far as it relates to Durgamari VDP is concerned, is liability satisfied, and a direction to have the state committee constituted with the petition as taken. So the Senate Council has also submitted that the record to show that the majority of the people are in support of the petition, and for some extraneous consideration and political pressure from the response number 5 has been sought to be favored. Per contra, the London State Council has submitted that the projection made by the petition is not correct. By referring to the affidavit in opposition filed on 29/7/2022, submitted that the tenure of the earlier committee in which the petitioner had served as the secretary was already over, and therefore a chance has been given to the respondent number 5. He has also drawn the attention of this court to the communication dated 30/3/2022 by the OC, whereby the name of the respondent number 5 has been forwarded. He submits that in the general meeting, there is a mention about there being certain complaints against the petition, and these factors were taken into consideration before taking the impunity. Responding to the submission, the Mahmood, the learned counsel for the petitioner, has submitted that though there were certain stray allegations against the petitioner, the minutes of meeting dated 27/2/2022 itself makes it clear that such allegations were held false. With regard to completion of the earlier tenure, the learned counsel for the petitioner has submitted that there is no bar for reappointment of an incumbent as secretary of a BDP, and in this regard, he has referred to a list annexed to the affidavit in reply dated 21/9/2022, wherein many incumbents have been appointed for tenure spreading over tenure much more than the tenure of 5 years.
Up to 45 years.
The learned counsel has also submitted that even in terms of qualification,
yes,
the petitioner better qualified, having passed the higher secondary examination, whereas the respondent number 4 does not have any formality.
Yes.
The rival submissions made by the learned counsel for the party have been duly considered. The impugned order dated 7/4/2020, by which the response number 5 has been made the secretary of the VDP in question, does not contain any reason. Full stop. This court has also seen that the order is is contrary to the resolution taken in the meeting, in the general meeting dated 27/2/2022, whereby the petitioner was found to be more suitable, and in fact the VDP was constituted with the petition as the secretary. Full stop. This court has also noticed that the respondent number 2 in his first affidavit dated 29/7/2020, more particular paragraph 5 thereof, has stated that the service of the petition as the VDP in the earlier tenure was satisfactory. Very satisfactory. Very was satisfactory. Full stop. So, the petitioner has also made a categorical statement in his reply affidavit in paragraph 8 that it is only because of political interference that the impugned order has been passed. Full stop. That though the London State Council has tried to defend the impugned decision by stating that the matter for appointment was left to the officers of the concerned police station, pursuant to which the letter dated 30/3/2020 was issued, the minutes of the general meeting dated 27/2/2022, which has been annexed, which is a part of the record, would itself show that not only the meeting was attended by the state officers, a conscious decision was taken to appoint the petition as the secretary of the VDP.
Considering his credibility.
Under such circumstances, this court is of the opinion that there is no acceptable reason as to why the impugned order dated impugned communication 7/4/2020 was issued by excluding the petition from the post of secretary and replacing his name by the respondent number 5. Such communication does not appear to be based on any relevant concept and rather appears to be cryptic and based on some irrelevant and extraneous concept. This court in exercise of powers under Article 2 of the Constitution is required to examine decision-making process, and in the instant case, the culmination of the decision-making process does not appear to be in consonance with the materials placed before this court, more particularly the minutes of the general meeting held on 27/20. this court is also unable to accept the defense made on behalf of respondents that the tenure of the petition being over, he was not appointed. That there being no bar in the statute for re-election and there being material things on record to show that incumbents are allowed to be reappointed, this court will not cannot accept the ground of defense. That accordingly, the writ stands allowed and to communicate 7% so far as formation of Durga Mari
Durga Mari, yes.
with the respondent of 5 that according to state is direct constituted with the petition as is in concern with the minor of gentlemen dated 27 in which the officer of concern were also present and had the allowed more.
But it may submit one constitutional order may be passed within a time.
Reconstituted, which he was
Highly obliged.
Because no copy was served to me.
we have asked your name.
Lordship, I'm keeping up with that.
Can we have show this to the Senate Council? You should have a look.
Maybe.
Just a minute. We were just sending over. Oh. After the narration, please read paragraph. I have just put a fact. Number 11. On the flag put. The 62 minutes have also been taken into consideration. 60 to 90 is the first meeting. That's been taken into consideration. And paragraph 11, there is a conclusion.
Yes.
We have tried to mark it.
Yes.
The correct position.
Correct position.
Yes. The correct position is that as per the decision of the IIT Council mentioned above, it is the chairperson of the IIT Council who has the powers to make short-term and officiating appointments of director of an IIT. The acceptance of resignation of Professor Sitaraman and his release from the directorship of IIT Guwahati will be only after due approval.
That may not be too much relevant.
No.
The power regarding can make the short-term arrangement.
What exactly?
Chairman of the council.
Chairman of the council
Council.
is below the minister concerned. Yes.
What is the present position regarding the finance director?
Chairman of the council.
Mr. Chaudhary, you can have a look at that.
Well, I've seen it. My lord, what I've seen it, my lord, also. Eventually, my lord, it is the chairman IIT Council who has made the appointment. Of course, there was a recommend from our client, my lord. There was a recommendation in favor of fifth respondent. But then, my lord, having laid down
In the decision-making process, don't you think that extraneous factors that should be taken into consideration?
my lord,
We are not against private respondent as such. But the first whether he was competent to make it. And he is not under recommended, he is appointed.
but then it was never acted upon.
No, he is not a layman. He is the chairman. He appoints. Something else, government chairman matter would have been different.
But then, my lord, the position is very clear. It is the chairman of the council who is
Yes,
competent.
and that part, well, sir. There can be no two views on this. Okay, we'll close this then. Whatever is the issue before us, we'll try to decide.
And secondly, my lord, regarding the selection stage, my learned friend would be in a better position.
He is not making any sense.
After 26, 27, nothing is moved. But my lord, from this it is also evident, I took part on 15th and 16th when shortlisting took place. But when on merit the selection was done, I was not there. For whatever reason, I was not there.
The selection has not been held because your absence could not come. That is the.
No, in fact, it appears some prior travel plan or something.
Okay, we'll close this.
Yes, the only thing, my lord, about the affidavit, paragraph 5.
Recent affidavit.
Yes.
Yes.
Your lordship, that your deponent begs to state that the above named Dr. Rajiv Modi, being a member of the search cum selection committee, participated in the first meeting, which was held on 15/6/23, and also in follow-up meeting on 16/8/23. In these meetings, discussions were held regarding criteria for shortlisting of the candidates, and accordingly, shortlisting of the candidates to be called for interview was done. Further, some of the names suggested by the SC members were also discussed during the meeting as such candidates. So the whole problem lies here, my lord. The crucial thing was if your lordship, the 26th order is also there of this court, that if he participates, it will be subject to the outcome of this honorable court order.
Which order? 26?
26/6.
23?
Yes, 23. Melody, if your lordship kindly recall page 25 of the decision which really governs the appointment of an officiating chairman, page 25 of the writ. In that meeting,
We have to.
your lordship remembers. Yes.
So that part is not computed.
Huh.
In the instructions, that correct question is the chairman of the council.
Yes. And the first email itself indicates the governor has violated that thing by saying that I am appointing in exercise of my powers in the statute, I am appointing a to be the thing, and date is also fixed for his. So without that, the appointment of the acting was absolutely illegal and contrary to the practice.
Now, just one question I'd like to pose. Now, as on today, the final selection is coming to a conclusion.
Apparently.
And where your client is outside, not in the fray.
No.
The private respondent is being considered.
Yes.
Now, is this final selection is not a part of the challenge here?
No.
Not a part of the challenge here.
Final selection has not taken place, but we have challenged two things. One, the appointment of the officiating as a departure from their rules as well as their practice, because three options are there, which they could have taken.
That we have taken note of.
Second is his participation in the process after the advertisement page. If he participates, as far as the candidates from IIT is concerned, he is definitely they are prejudiced, because his second email says that I have considered everyone, and they are not what's even for the post of deputy director.
Look, can I make one submission?
First, he appoints the secretary your lordship sees, that is the second one. It is coming from the Secretary of the Government of India, expressing gratefulness for taking time off by the governor and not pointing out that what he is doing is not in terms of the law. And he says that, do you have the seniority list and all that? And third and second email of the governor comes and he says, I have considered everything. And we have categorically stated that these reports or the biodata of these 58 people were never sent to him. He has picked up this man, he has continued to back him, and he is attending 2 meetings, crucial meetings, where shortlisting is done, including the 8 candidates from this institute.
Now, you are aware that you are not within the shortlisted candidate.
No.
Now that part you need to challenge.
No, that is apart. His participation, we have questioned.
That is okay. But
We have questioned in the petition so far as
Mr.
the...
Goswami, even if we assuming we pass a direction that in the final selection he will not participate. But in the meantime, something has already been done.
No, my lord, this final, your lord, that's why I placed paragraph 5. They have virtually selected the candidate. My lord, kindly see, shortlisting has already taken place. 8 from this institute applied. 2 have been selected. And the prejudice which has taken place not only to the petitioner but all the others is apparent, because his email says about everyone. If that is permissible, my lord, then why should he be participating? He should have, the minister should have taken his recommendation and his appointment and passed the order.
Well, all that I was trying to submit to my lord. Let the selection conclude and let the selection be placed before lordship in a seal cover. Supposing my lord, respondent number 5 is not selected. Someone else is selected, then what happens? Then your lordship's exercise will be futile. So let my lord the government, the search and selection committee complete the selection, place it before lordships in a seal cover. Once lordship finds that respondent number 5 is selected, then lordship will take a view. Otherwise, if he is not even selected, then this entire thing will become academic. That's what I feel, my lord.
That is what we are also.
So let them produce it, and then lordships can take a view regarding, then my lord, maybe what my learned friend is saying is correct, or maybe it has got some force. But as of now,
so far as the prejudice part is concerned, that has already taken place. He has attended both the meetings of the search committee, where shortlisting was done.
No, what Mr. Chaudhary is trying to submit
is
the bias is not against you. The bias is in favor of the private respondent.
Yes.
If he is outside,
if he
is not ultimately selected,
then it may be. Then also, with great respect, I submit, your lordship. That's why at page 13 we say that in any event, this is for the first time a departure from the norms. And if you allow that, it is a dangerous development which can be repeated in other IITs. Therefore, this declaration is needed that what was done is absolutely not in terms of the, so far the officiating appointment is concerned, is not in accordance with the norms prescribed. That is necessary, Vinod. That is necessary in the interest of IIT in India. It has never happened. This has happened for the first time. The 3 options are very clear, and that has been followed uniformly. That is part of our prayer also. We have made that prayer. We have said that this officiating appointment is bad. Secondly, if he participates, then the candidates from this institute will be prejudiced. If your lordships ultimately find that the person concerned is not selected, that may be one situation. But the fact the fact that he participated is itself vitiates the process pursuant to the advertisement, and which is part of the check.
You had given the shortlisted candidate last time. Where is it? Okay. Yes.
Your lordship will like to keep it on your lordship's record.
That is
Yes.
a court document. But this matter, and I heard speaking to the senior counsel for the petition. Also heard. RP 40, senior counsel for IIT. Senior counsel is present for the response number
3, my lord, 3 and 4 by name, 3,
3
and
and
4.
4. 3 and 4. Whereas the response number, Bhattacharya, he has Bhattacharya. He is present for the response numbers 1, 2, and 6. Also, this matter was substantively heard on earlier occasion, and an affidavit was directly filed by that which has according to be done on 10/10/2023. The Bhattacharya has also faced certain written instructions received by him on record of court. The matter is reserved for passing of necessary order.
Correct position, as they are saying, should have been mirrored as per the procedure prescribed, which is not the case in the instant case. Therefore, the last instruction also is faulty. Deeply obliged.
We have written that instruction that was meant for you. Do you have a copy? Do you have a copy?
Obliged.
May please, your lord.
Yes.
Lordship, in this case, PS Locker is appearing as the central government counsel, and he has to take his father-in-law to the hospital, Lordship.
What is the
Matter, lordship, relates to that service where during the course of a service, the sepoy gets injured and he's.
Oh, he is out of book.
Yes.
When did he have next week?
Lordship, in that case, after it will be to go after vacation, Lord.
What is your age?
55, 5 years more left.
Which is the date?
14.
While PK Mohammed Bennett asked for the a prayer for adjournment has been made on behalf of T.S. Crawford, who could not attend the court due to some medical emergency. This meeting have been active with this for on
14. Oblige, your lord. No for kindly no further adjournment. Oblige.
May please, my lord. My lord, matter pertains to, my lord, we are challenging the post of assistant professor, my lord. Ames Guwahati, my lord, microbiology department. My lord, my senior Mr. Nair is on leg. My lord, may kindly fix it at 2. He's almost done with his article. If it pleases, my lord, at 2.
Okay, we'll see. Now, are you ready with the record?
Here.
Highly obliged, my lord.
Your lordship has actually substantially heard the matter. It is in relation to that application of the date of suspension, effective date of suspension, as to when it is effective. So here, your lordship, if I'll just take your lordship, the suspension order, which is at page number 104, and the suspension order was issued on 1st of November 2022. And
You're challenging one.
I'm challenging the extension of the suspension order, the review order, because it was not done in terms of rule 10.6 and 10.7 of the CCSCC rule within 90 days. And in terms of the Deepak Mali judgment.
And is that period of 90 days, even the DP was not.
No, DP was still later on.
But where is the issue? What's the control?
The controversy is as to the effective date of communication of that particular suspension order. In my humble submission, your lordship, it is from the date of issuance of the suspension order. In terms of the judgment laid out in Khemiram case, which I have supplied there and record, your lordship.
It will copy.
Yes. And in terms of the Khemiram judgment, it is from the date of the issuance of that particular, and more particularly para 70. I've highlighted that portion from when that effective portion. It will be seen 14th line, your lordship, para 17.
Para
17. It will be seen that in all the decisions cited before us, it was the communication of the impugned order which was held to be essential and not its actual receipt by the officer concerned. And such communication was held to be necessary because till the order is issued and actually sent out to the person concerned, the authority making such order would be in a position to change his mind and modify it if it thought fit. But once such order is sent out, it goes out of the control of such an authority, and therefore there would be no chance whatsoever of his changing his mind or modifying it. In our view, once an order is issued and is sent out to the concerned government servant, it must be held to have been communicated to him, no matter when he actually received it. We find it difficult to persuade ourselves to accept the view that it is only from date of actual receipt by him that the order becomes effective. If that be the true meaning of communication, it would be possible for a government servant to effectively thwart an order by avoiding receipt of it by one method or the other till after the date of his retirement, even though such an order is passed and dispatched to him before such date. An officer against whom an action is sought to be taken thus may go away from the address given by him for service of such orders, or may deliberately give wrong address and thus prevent or delay his receipt and be able to defeat his service on him. Such a meaning of the word communication ought not to be given unless the provision in question expressly so provides. Actual knowledge of him of an order where it is one of dismissal may perhaps become necessary because of the consequences which the decision in the state of Punjab versus Amar Singh contemplates. But such consequences would not occur in the case of an officer who has proceeded on leave and against whom an order of suspension is passed, because in his case there is no question of his doing any act or passing any order, and such act or order being challenged as invalid. Your Lordship, this particular issue settles everything because the contention raised by the respondents herein, it is because I received this suspension order on 7th of November.
Give us the date.
I received it on 7th of November.
Give us the date.
The original date of suspension order is at page.
You are working as what?
I am working as a superintending engineer in the Porters organization. And when I
BRO.
BRO. And when
Where were you posted?
when I was there, when I was deputed to go on deputation to NHIDCL, certain allegations arose as to my integrity.
NHA where?
NHIDCL.
Where is it?
It's in Delhi. And
There were certain allegations.
certain allegations were raised, and
Order of suspension is dated for
it's 1st November 2022, page 104.
on 7/22
22
suspension order.
suspension order.
Cannot have-
I received it on 7th of November 2022 because I was on leave at that particular point of time. And in my humble submission, this 90 days period would end on 29th of January 2023. They had to review this suspension order
And on
29th of January 2023. And
here
yet
what they have done.
it has been done on 3rd of February 2023, beyond the 90 days. And in terms of the Deepak Mali judgment, I have supplied it on last occasion also. It is there on record, Your Lordship. In terms of para 11, the Deepak Mali judgment, it's 2010 2 SCC 222. Para 10 and 11. This it is mandatory to hold a review within 90 days, before the expiry of 90 days, not even under 90 days. And after that, it becomes invalid, the whole suspension order. So, in terms of this judgment, this particular review was done on 3rd of February, which is at page number 106. of February 2023. And against that review, I submitted a representation, and
Where is the review?
page 106.
106. 3rd February.
3rd February. And I received it on 12th of February.
Yes. That's all?
That's
Yes.
Well, so for me, before that, I pointed out the order is it 1/8/2023
Of
in repeat order of disciplinary. 1/8/2023.
1/8/2022.
23. 1st August 23. Now we just run. On submission made by Learned Counsel for the petitioner was to that effect that the order of first review of suspension of petitioner was issued on 3rd February 2023, which was started on 12 to 12 February 2023. Accordingly, he submitted that even if the initial order of suspension is found to be sustainable, the order of first review having been started beyond the period of subsequent 90 days is bad in law, which is stated this. And Departmental of providing this statement, Central Government Council has submitted that he has received instruction on his mobile, specifically stating that the order of the first review of suspension order dated 3 to 2003 was started on him on the same date. Accordingly, he pressed for time to file an affidavit to bring it in record. The respondent shall file a petition affidavit to bring on record any stand they intend to take in the litigation, specifically regard the service of notice and first review order of suspension of 3/2/2023. Accordingly, here on that occasion, when matter was hard, towards the subsequent review order was he received on 12. It is his submission. That part I have to clear. But
the on record speak, my lord, on the same day it was handed over. I submitted the affidavit of indebtedness. This is one aspect, my lord. Another aspect, my lord, is properties.
No, but that's not the issue.
Yes, I want to clarify. So, another issue, my lord, is this proper Kemiram is concerned, my lord. It was, my lord, from the date of communication of the order. From not date of the receipt of the order.
Yes.
Here, my lord, we have the suspension order was issued on 1st November 2022, my lord.
Correct.
And it was communicated to him on 7th. Communicated to him on 7th. On the same day he received. The other case, my lord, is that case, Kemiram was, my lord, his allegation was, my lord, on 31st July, my lord, on the date here, my lord, it was communicated through telegram. He received on 4th of August. On 4th of August, he in North Service in Kemiram. So his claim, my lord, I received on 4th, my lord. So it should be from after retired, I received the suspension order. So it is very in law. But the Honorable Supreme Court in Punjab, yes, my lord, when initially it was communicated on 31st July, the effect will be from the date of communication. So here, my lord, this suspension order issued on 1st of November and communicated to him on 7th. So in that aspect, my lord, when the question was asked by the Honorable Court, and we have filed an affidavit also, my lord, regarding the effect of the suspension order. It was, my lord, filed on 5th of April 2023, my lord.
Was the order except the form of an order on 1st of November, or was it in the order file noting?
My lord,
it was not in the shape of a file
it
noting.
is form of order, my lord. But
Order.
yes,
The
but
order is dated 1
yes,
11.
there sir, in represent annex, my lord, is the 105 case, 105, my lord. 104, my lord, is the order suspension order, my lord. 105, my lord, is the page 105.
105.
Yes, ma'am. Next, sir, 13. Forwarding of suspension order. The acknowledgement of in token having received from this is on 4th, my lord, and 4th of November. That terminal on 7, it was communicated to him, my lord. This our stand, my lord. And what is so far, my lord, the Deepak Malik case, my lord. So for Deepak Malik's case is SLP of 2006, my lord. And thereafter there is this amendment, my lord, the rule 10, my lord, April 6, my lord. Of Central Service Civil Service, my lord, 1965.
I have quoted.
Yes, my lord, this in this case, my lord, there is also this office memorandum, the NX by my lord, page 122, my lord.
Page
122, 120.
122.
Yes. After this amendment, my lord, this. If paragraph 4, my lord, and this I'm reading this, my lord, this from this rule, my lord, this same thing is here, my lord. In order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke.
Where are you reading paragraph?
My lord, I'm reading from the CCS rule, my lord. The same thing is here, my lord.
page 20 of the writ petition, I quoted Rule 6 and Rule 7.
Here it is written 120 in deemed suspension under Rule Sub-Rule 2 that the date of order of suspension may be much later than the deemed date of suspension. With a view to make this provision implicit in Sub-Rule 6, the aforesaid Rule 10 now have been amended to substitute the word 90 days from the date of order of suspension, occurring therein within 90 days from the date of effective date of suspension. The consequence upon the amendment it will henceforth be necessary to specify in order of suspension effective date of suspension. But here will be from the date of expiry from the date from the 90 days from the effective date of suspension. So, my lord, in this record, my lord, we file affidavit, my lord, this outdated the effective date of suspension. Accordingly, suspension allowance also, my lord, from the 7/11/2022, my lord, 7 November. He received suspension, my lord, allowance, my lord, from the 7/11/2022, my lord. That is the date of effect of suspension, my lord. On recommendation of review committee. So, my lord, from the 7th of my lord, this 7/11, my lord. My lord, this only this our mail is from the effective date, whether it is from 1st of November or from the 7th. So for our stand, my lord, it was communicated as per the camera, it was communicated to him, my lord, on 7, my lord. It was not received and communicate from our side, received from his side. Similar case, my lord, is against. So far, I understand against the petitioner, my lord. It was it is by the petition, the camera, my lord. So Supreme Court says, my lord, is no, my lord, when this it was communicated from that date. So we communicate him on 7. So that this from the date, my lord, 3rd of February, it is within 90 days, my lord. So interference of, because another is the allegation of this, there is he was the executive director in the one project in Bhutan. It is more 199 course.
I'm not on merit.
Yes, I'm not on merit. Maybe.
I'm not on merit.
So, and another is they already this 2 months is there, my lord, is already first January it will be completed, my lord. So at the stage, my lord, the proceeding is there, my lord, and there is telephonic, my lord, is recording, everything is there, my lord, and the only the date question, my lord, is only this, my lord, the effective date, my lord. Whether and Deepak Mali cases, my lord, is 2006, my lord, now then this amendment 2007, my lord. This is the date of effective, my lord. This is my humble statement. At least this now court may not interfere in this context.
Pass order.
Yes.
Oblige, Lord.
Today, my lord,
Today is the
at 2.
not not this time.
Yes, my lord, I have one case in court number 1 and 2.
No, we not pass orders. Pass orders.
Yes, ma'am.
Ready. The third report. Council for petition also for
I'm 1 to 4, my lord.
anyone else? 4, 5, and 6.
Anything.
And they are 1 and architect.
I'm 1 to 4.
1,
2, 4. 1, 1, 2, 3.
1, 4. Architect. Person of hearing.
Hello.
Oblige.
all matter 2009 matter, where because of one this thing, guideline and circular of railway, the RPF and RPSF, they are not allowed to join for departmental in other department. So here the case is I'm from RSPF, and RPF and RSPF, they are not allowed to join in the account section, but RPF were allowed to join, and I'm only the one from RSPF. That's the whole issue. And I have been continuing the service since 2009 in procedural interim order passed by this honorable court. And now I have been promoted even to the rank of assistant accountant. 2 promotion I have already gone up. And from this department also, they have requested to retain me here in Maligaon. We'll give a try tomorrow. In this, my lord, see, may kindly fix after vacation. So my learned friend has suggested for 9th of November.
Let's try tomorrow.
My lord.
Possible, otherwise.
My lord. Obliged.
A prayer for accommodation has been made on behalf of the RKD Learned Deputy HPI. Full stop. Considering that this is of the year 2012, this again tomorrow.
Obliged.
I apologize for not being here. My lord, this is that Ames matter, wherein a recruitment process was initiated. My lord, for different posts, I had applied for microbiology, associate professor, and assistant professor. Then,
you said same interview.
One interview, my lord, there were 2 markings. Same questions, only one set of questions asked to me, my lord. And then there was, I did not know. When the marks came out, when the select list was published, for associate professor, I was kept as waitlisted candidate number 1. And respondent number 5 was kept as waitlisted candidate number 2.
For associate?
My lord, for associate professor. Petitioner as serial number, waitlisted candidate number 1, my lord.
And R number?
R5 as
number?
R5 as waitlisted number 2. Then, my lord, the assistant professor was declared. Therein, the R5 and R6 was selected. I am not even there in the waitlist. One selection and the marking is there. Then, my lord, I made an RTI. I made an RTI application with the specific question that whether there was one and same interview for both the posts. They came up and said, the reply was there was one and same interview. Thereafter, under RTI, I got the marks, my lord. In the marks, I find that where I scored 67.3%, my lord, for associate professor, R5, my lord, got 66.8, and R6 got 62%. Now, my lord, for assistant professor, I got 63.1. R5 68.2.
63.1.
63.1. And R5 68.2. R6 67.
Yes.
My lord, I have put to challenge their appointments. Now, in the affidavit that has been filed by Ames, my lord, although in para 7, page 132, they say, it's true, my lord, there were separate attendance sheets signed by us. Para 7, 132, my lord. I'll have the second line, my lord. The interview for the post of associate professor and assistant professor was conducted in immediate succession by the standing selection committee panel on 23/4/22. Separate attendance sheet and separate assessment sheets were maintained for the purpose. Now, my lord, at para 9, this is in response to my para 8, wherein I had referred to the, my lord, RTI reply.
Did you face 2 interviews?
No, 1 interview.
So what is the meaning then? Conducted in immediate
Succession. They say that there were 2 interviews. That is clarified in para 9, my lord, page 133. One 33, my lord. Para 9. Yes. My lord, that with regard to the statements made in para 8, the deponent begs to state that the interview for the post of associate professor and assistant professor in microbiology was conducted together by the standing selection committee on 23/4/22, which was mentioned as one and same to the specific query in the RTI application of the third party named so and so. Now, my lord, as a matter of fact, separate attendance and separate assessment sheets were maintained. Now, my lord, comes to page 134, para 11. Para 11. That with, in respect of the statements made in para 11 and 12, the deponent, while reiterating and relying the statements made in para 10 of the affidavit in opposition, so and so petitioner's condition that candidate who qualifies for the higher post automatically qualifies, becomes eligible for the lower post. Though same selection committee interviewed the candidates for both the posts, but separate assessment for each of the 2 posts were made by the selection committee, and as such, qualifying in one post does not make the candidates qualified for the other post. Then, my lord, at page 138, para 17. That with regard to the statement made in paragraph 18, the deponent begs to state that the post of associate professor and assistant professor was conducted on 23/4/22 by the standing selection committee in a single session. Upon informing this to the candidates attending the interview and having recorded the attendance separately, so and so in prescribed attendance sheets, similarly marked were awarded in 2 separate mark sheets by the standing selection committee. Thus, petitioner having been placed in number 1 of the waiting list for the post of associate professor does not make him eligible for the post of assistant professor, for which separate assessment has been made. Now, my lord, would have page 140. Yes. My lord, this is the attendance sheet signed by us for the post of associate professor. Now, my lord would have the date and time of interview. My lord has got it. 23/4/22 at 9 a.m. Next page, my lord, 141. This is for assistant professor. My lord, 141, assistant professor attendance sheet. My lord would see the time of the interview, 23/4/22, 9 a.m. Now, my lord, these interviews were scheduled not post-wise, my lord, but department-wise. I'll show that, my lord. Now, my lord, the recommendation or the minutes for the post of associate professor, my lord, is at 147. Yes. This may, my lord, is nothing. My lord can skip 147. My lord can come to 148. The selection committee was provided with the applications, the biodata and copies of the certificates of eligible candidates who entered in the interview for the post of so-and-so. After perusal of the same, they conducted the personal interview of the candidates who appeared in the interview. The selection committee has decided that the total marks in the selection is 100 marks. The cutoff marks for selection UR is 65. The selection committee had evaluated the performance of all candidates in the interview who attended the interview and awarded marks as per attached mark sheets. It is also certified that none of the candidates shortlisted for interview were related to them. Based on their personal interview marks, the selection committee recommended the following candidates as per merits for appointment to the post of so-and-so on regular basis. My Lord, Deep Jyoti Kolita was appointed. I am there at serial number 1 and serial number 2 is Kaushalya Raghuram. Now, my Lord would see another anomaly here.
Kaushalya is the respondent.
Respondent, madam. Respondent number 5. My Lord, this is the seat wherein, my Lord, they have signed. My Lord would find there were in total 9 persons who had interviewed, my Lord. The interview body consisted of 9 persons. 2 did not attend. So there were 7, my Lord, who were marking. My Lord would say this. My Lord, DGHS, Ministry of Home and Family Welfare, did not attend. Just opposite to that, Dr. Professor Dilip Chandra Nath, Vice Chancellor, did not attend. Now, my Lord, say, Rangappa signature is there. Aarti Kapil signature is not there. She is a subject expert. Then, my Lord, Ramji Singh is there. Dr. Tulsi Bhatto is there. Then, my Lord, just above Tulsi Bhatto, Professor Babul Besburua is there. Captain, group captain, so-and-so is a subject expert. He is not there. Professor Narayan Babu has not signed. Now, my Lord turns over to the next page.
What is the subject? Your
Microbiology, madam. Aarti Kapil and Captain SP Singh are the, my Lord, subject experts. So, in the first sheet that was prepared, their signatures are not there. If my Lord comes to the next page, here, my Lord, Captain GP Singh, along with Rangappa, Ramji, the chairman, and Babul Besburua signs. My Lord turns over to 140, 150. It's again, Dr. Singh is not there. Aarti Kapil is not there. Now, 151. Here, my Lord would again find only the signature of Aarti Kapil coming in.
No, but you have said that out of 9 members, how many has signed?
7 had marked, my Lord.
Where? In page
in the that marking, my Lord would find at page 157. 157. Associate Professor. Interview 23/4/22, 9 AM. My Lord, Professor Tulsi Bhattaji, Professor Babul Besburua, the DGS member and Professor Dilip Chandra Nath did not participate.
Yes.
KS Rangappa, Narayan Babu, Ramji Singh, Aarti Kapil, Group Captain Dr. SP Singh. So out of 9, 7 participated. But my Lord, for that, they had to use 1, 2, 3, 4 minute sheets for the signature. And no explanation for that. So, my Lord, it was done, maybe, my Lord, after the RTIs and all were made to make up the things.
No, that
I'm just showing, my Lord. And then, my Lord.
At times, after the interview, the person leaves. So it gets signed somewhere else also. Not the problem.
But, my Lord, they have not been there. Fine, my Lord. Let's give them that, because that's not my case also. Then, my Lord, here markings, my Lord, would find at 157.
Yes.
My markings are at 158. Serially, my Lord, 12, 13, and 14. Petitioner R5 and R6. Now, my Lord, I was given marking in this manner. 67.3. Kaushalya was given 66.8. Rajeshri was given 62. Now, based on the same questions, when it comes for the, my lord, assistant professor, my lord, 159 it starts. Mine is at 160, serial number 19. Page 159 is the marks, consolidated mark sheet.
Where are you?
My lord, I am at serial number 19 at page 160. R5 is at serial number 13, my lord.
Where are you?
My lord, 19.
You're at 19.
19, my lord. Vikramjit Datta, that's the petitioner, my lord. R5 is at serial number 13 and R6 is at 161, serial number 28.
Kausalya is R.
Kausalya is R5, my lord.
She gets 68.
She gets now 68, marks have been, my lord, enhanced. Whereas, my lord, 19, whereas for associate professor, I got 73, now given 64. 70 has been made 62. 62 increased. 70, 64.
And 20 what?
20, my lord, 28 is R.
Rajeshwari.
Rajeshwari R6, man. Her marks has also been increased, man. My contention before my lord is that if there were one set of questions asked, my lord, there cannot be two satisfactions drawn on that. There has to be one satisfaction, which is the satisfaction drawn for the post of associate professor, the markings.
Now you see the total number of candidates vary for an assistant professor and assistant professor. In fact, you one who is applying for assistant professor, he can very well apply for assistant. But one who is applying for assistant, he may not be.
But my lord, here all the three candidates who were the prime, my lord, including the selected two candidates, they both had applied for associate as well as assistant. And the interviews, my lord,
that part we are clear. If you have been assessed only one,
lordship,
along with the response, only
lordship,
one,
only one,
two set of marks,
lordship,
this will automatically raise some doubts. How come it?
Lordship.
But if you are assessed twice,
then it's a different thing altogether.
One for the purpose of assistant professor, one for the purpose of assistant professor.
It was not done. That's my case.
Now we have to see.
My lord would have, my lord, few states.
If your projection is correct on fact, that's probably a case for interference is made up.
Lordship.
We only want to know the factual point.
That much only, my lord. If they had held two interviews, my lord, I would not have had it because that assessment can differ, my lord.
Can differ.
Because there would be new candidates coming in, there can be a assessment differ.
And even questions may differ.
Differ, my lord. So now, if you have asked one set of questions, then, my lord, you cannot have two outputs. And my lord, interesting part here is the affidavits have been filed by respondent number R5 and R6. They have not dealt with the paragraphs that I have, wherein I said, my lord, singular inquiry, one interview was there.
So what about the
department, my lord, that paragraph I showed you, my 9, that much only, my lord. Beyond that, they have not said anything. Now, the R5, my lord, affidavit, my lord, para 7 at page 132, succession. Then, my lord, 133, when I refer to the...
We conducted together. They could have very well spelled out because the owners will shift upon them. No, we had two interviews.
Lordship.
That they have not said.
They have not said. Two separate interviews, not said. They took two attendance sheets, madam, and then said we made two assessments. Basing on the same question, my lord, there cannot be two assessments. That's my case, madam. In the
yes, madam. You for?
I am for number 8.
1 to 4.
Same.
And lordship, just to, my lord, clarify that contention that I'm trying to raise, My lord, page 15 of the repetition. It's part of para 8, my lord.
1.5.
1.5, my lord.
Yes.
My lord, the last line in the first paragraph, my lord. It is also been stated in the RTI reply that no separate interviews were conducted for the post of associate and assistant professor, the interview being one and the same for both the posts. And that is the response, my lord, in para 9 at page 153. And the, my lord, now another para 11, page 18, my lord. Just to show before my lord that these contentions have not been countered. Para 11, my lord, the second line again.
Yes.
The selection committee conducted one interview for both the posts with the same members and found the petitioner suitable for the post of associate professor, but not for the post of assistant professor, which is surprisingly as a candidate who is eligible for the is automatically eligible for the lower post. Now, my lord, para 15. But my lord, that there is a categorical statement, my lord, in para 22, page 22, my lord. And these have not been denied. It can be clearly be seen that despite having one single
Where? Page 22?
Mala, page 22, line starting with it, Mala, top line, top Mala. It can be clearly seen that despite of having one single interview for both the posts, the petitioner has been awarded two sets of marks, one for the post of so-and-so and one for the post of so-and-so, assistant professor. And these paragraphs have not even been dealt with by respondent number 5 and 6 in their appeal. This is my case.
Yes, madam.
Okay. As per the notification notice, interview notification page 65, it is clearly stated that for all the department process, single interview will be held for all the faculty posts. Page 65 of the repetition. For each department, one single day has been scheduled for interview, and one selection committee has interviewed for all the faculty for the post of all the faculty members. Let's say here the microbiology was fixed on 23/4/2022.
Okay.
And it was petitioner's knowledge that a single interview will be held for all the posts. He has not challenged it or objected to it, or neither he has sought any clarification in this respect, because in the notification itself, Lordship, in page 47, it is clearly stated that if you have any queries regarding clarification or queries.
Madam, have you understood the case of the petitioner?
Lordship,
What is this kind of submission you are
this
making?
single, it
Is
was,
he challenging the single interview? Is that the issue even?
they have said that.
Why don't you address the issue? We want to know whether you had a single interview for both the posts or you had separate interviews. That is the end of the matter.
Last time in the affidavit, it is categorically stated that in quick succession, last time one after another, the interview was held. The assistant professor and associate professor, and separate assessment sheet has been maintained, separate attendance sheet has been maintained, and merit position has been considered.
Then how if it's for the same department, same person gets more marks in one category and less marks in other category vis-a-vis the other private respondents? Why? How can the assessment differ? Department is the same.
Department same, Lordship, but post is different. Associate professor and assistant
That is
professor.
the reason you are showing 65. It is not post-wise, it is department-wise.
Department-wise.
So,
and for all the departments, Lordship, a single interview has been held, and selected candidate.
Department-wise single interview. Microbiology, you had interview on 23. He had showed at least 4 paragraphs where he has categorically stated that it was one interview. We had faced one interview.
One interview in quick succession lordship, but separately assessment has
That
been
is
made.
it. How can you make different assessment? Did you ask the questions on 2 sets? One for assistant professor, one for assistant professor. Is that your case? He said for interview twice. One for assistant, one for assistant. That is not your case. You have not specified. Yes, we held in quick succession. One after the other. He was made to sit twice.
But the assessment is different lordship. For one post is
Questions will be the same.
question lordship, whether question is same is.
Can you
not-
answer this question is meant for assistant, this is for assistant. If you are having is sitting only one. If he is made to sit twice, yes, we are now sitting for assistant. These are the questions you answer. Then again, after some time, now we are holding for assistant. This is the question you answer. Have separate assistants. You ask questions in one sitting, give 2 marks. Why? What is the justification? You had the chance to file the affidavit, which you have filed. You could have said, no, there were 2 interviews. Rather, you have supported the case. At least 4 paragraphs, no reply. Single interview is not the subject matter challenge. He is in fact taking advantage of single interview. To us, anything?
I appear for the private respondents who have been my lord otherwise selected and we are presently working. We have left our job my lord from my lord.
That we are not too much bothered. We are on the decision making process.
Well, here,
What
my
you
lord,
had earlier, what you are having later, we are not too bothered at all.
but the issue
We
is
want
this,
to see the decision making processes.
well, later produce the record, my lord, entire record.
The affidavit, what has it stated? Your role is very limited.
So my role is limited, but my
You
lord,
can,
one
you
thing,
can only portray your credentials before this court that I am.
the credential, my lord, that part is no, my lord, there is no doubt about it.
That is only your part.
And I have, my lord, in that regard, I have some submissions to make.
You have not even stated that his basic submission that it was one interview. There is no reply.
So my lord, so far as the attendance, my lord, it is concerned, there are 2 attendance sheets.
Attendance is
And my lord,
true.
one more thing, my lord.
Yes.
Regarding that, my lord, right of the petitioner to challenge this particular, my lord, selection. That is the methodology of selection. After, my lord, the results are declared. And the judgments of the apex court is very clear, my lord. He appeared in the interview. And why he waited for about 1 month, my lord, up till the declaration of the result. And that apart, my lord, the claim of the petitioner is this, that, my lord, he was otherwise waitlisted candidate number 1 in the post for associate professor,
Correct.
which is above the, my lord, assistant professor. Now, Lordship will see in the post of assistant professor, if Lordship may kindly turn to page 97, my lord.
Yes, we have the mark.
Yes. Lordship will see, my lord, in the results sheet too, there are not only these 2, my lord, private respondent number 5 and 6 who have been selected, there are 2 waitlisted candidates above the petitioner. So on merit, my lord, for that particular post, others also is not entitled.
But if he is above you in a particular
But
category,
that is a totally different post, my lord.
for the same interview, in the same interview, you may fill up 10 posts, hold one interview, get it different marks.
My lord,
For
that-
this post, I give 10 to same person, same
So,
question.
my lord, let them produce the record, my lord. What Lordship will see the marking sheet, my lord, whether it is separate or, my lord, same, my lord.
Separate marks has been allowed.
At least that should be, my lord. After all, our features are at stake, my lord.
These are the marks, they are part of the record. Why should I go call for the mark sheet?
Lordship, from the
Who
mark
is
sheet,
disputing that there are no separate mark sheets? But how could you allow separate marks? Not to you, to madam.
My lord, in this regard, my lord, it will be the, my lord.
And where is your, where, Mr. Gogoi, you are saying many things. Where is your reply
My lord.
to the basic contention? You have not even replied.
Page 119, 8M.
At least 4 paragraphs he has stated.
My lord, there is
He has
only
got
one.
RTI.
My lord. RTI manner no way state though, my lord. That manner effect they have seen their affidavit.
Lordship, in the
They have
affidavit
annexed,
it
my
is
lord.
replied, Lordship.
They have annexed, my lord.
Ames has explained the RTI. This is the meaning. What else is it?
Lordship, this is a methodology accepted in all, in respect of all the departments. And
Yes, if this is my lord wrong, my lord, the entire selection goes for every
Let
department.
it
my
be
lord. That cannot
challenged.
be.
Are we here to decide this which is not before us?
No, otherwise also, my lord.
Something is
Every
going wrong.
selection.
Nobody has come to the court. We act on our own. We don't have that much of liberty or time.
No, I'm not saying that, my lord, but the methodology was my lord, duly applied
Sorry.
to all.
Lordship,
Doesn't appear to be very reasonable at all.
Lordship, in the
No,
advertisement.
Lordship may at least fill in the record in that case.
When there is a dispute or some understanding problem with the affidavit, we'll produce the records definitely. In the affidavit, there is no averment.
Lordship, assessment has been made for separately for the post lordship, and separate marks has been allocated.
That
And
we have
the
seen,
part
madam.
of-
That we
part
don't
of
need to
my-
repeat. We have seen the assessment. But what is the basis?
This is the methodology lordship accepted in all the, in respect of all the departments, and in the advertisement itself, lordship, it is clearly stated, and they have not objected to it and appeared in the interview, and after.
Was there an occasion to challenge at that time?
Yes.
No, my lord, after
Was
the
there an
interview.
occasion to challenge? If you hold one assessment or two assessments, it is only on declaration of the result. He will know that for one post, he's been assessed as
No, it is
so.
mentioned in the my lord, letter, my lord, whereby he was called for interview. It is
Yes.
there, my lord. It is there.
What is that mentioned?
Lordship, in the notification, it
Yes,
is
madam.
clearly stated, lordship, for all the faculty members, one interview will be held.
My lord, page 65, it is
You
mentioned,
are
my lord.
admitting, madam, one interview will be held. That is what his case
I'm
is.
saying,
That is what his case is.
Lordship, but assessment is different for both the post lordship. Separate assessment has been made.
That,
for-
my lord, in the affidavit, they have clarified.
It is clarified.
Where is the clarification, Mr.
It's
Bogoi?
there, my lord.
Let us know. Please show us.
One pair 5.
We have seen the affidavit of Ames. 5, 6,
Yes, pair 7, my lord.
Para 7. This accession.
Yes.
Please
So
come.
separate, my lord, assessment was made.
Yes,
by
then
successive
come to page 9, paragraph 9.
Paragraph 9, lordship, it is
Interview conducted together.
clarified, lordship.
What was the difficulty in saying that no, we had held two into he had said for 2 times. You questioned him once, give 2 marks. What is the justification? What prevented you from writing that? One more line.
No, they have replied about the RTI, my lord. RTI.
What else? What is that a
Near reading, my
reply?
lord. The deponent begs to state that the
Interview
interview with the post
conducted
of
together.
associate professor and assistant professor in microbiology was conducted together by the standing selection committee on so, which was mentioned as, they have only, my lord, repeated what was there in the RTI, which was mentioned as
Thereafter,
one in
is there any further explanation? Is there any further explanation?
to the specific query in the RTI application of a third party named Sri.
It is very
Sandeep
convenient for
Kumar
you to
Deori,
say
as a
that
matter
that's
of
an
fact,
explanation.
separate attendance and separate assessment sheets were maintained for the interview of both the posts.
Why not another line? That assessment was done separately.
Yes.
Where, madam? Yes, here, where?
It is a paragraph 7
Where
is
it
very
was?
clear.
Lordship,
My lord, para 8 again, my lord.
5, lord.
Paragraph?
Paragraph 5 of our.
Yes, let us see. Page.
Yes.
My lord, 131.
131.
The deponent begs to state that the selection process was based on the candidate's performance in interview conducted by the standing selection committee and the subject expert. As per assessment by the interview board, the marks were awarded separately for the post of
Yes.
associate professor and assistant
That is the
professor.
case of the
to
case of
all
the petitioner.
This-
That is the case of the petitioner. The separate marks have been given. You have been given a chance to explain the effect. You just have to say that yes, on the same day, same time we had called. But for assistant professor, we had held interview, and for assistant professor, we after one after the other, and they were made to sit separate twice. the comment condition. You have assessed them once. How can in one assessment, same assessment, once you get 10 marks, once you get 9 marks? Why? And it is not the petitioner. There are many candidates who are common. All their marks differ. Why?
Okay, I will.
At least, my lord, let me allow my lord, have to produce the record on this point, at least on Monday, my lord, 1 day's time. After all, my lord, somebody has already been selected. They will at least, my lord, for satisfaction of the honorable court.
What else can you?
Let-
We
let-
would have granted time. We would have, if there was any. What can you show?
Even my lord, one chance, my lord,
That's, my lord, I would have understood that even if, my lord, the
No,
persons who are appearing, if your lordship can come to page 119, that 2 paragraphs of my writ petition, wherein I categorically said that there was 1 interview, 2 assessments. My lord would see para 11, page 109. That is the affidavit of respondent number 5.
Yes, paragraph
11, my lord, page 119.
that you have seen.
The deponent has no comments to offer as the matters of record. However, anything beyond the record.
my lord, how my lord it was held, it will
That
record
means
this
I'm
week,
right.
my lord.
You had appeared. You were there in the interview.
No, I
And you say
understand.
it's part of record. Won't you say that yes,
Then
I had
it's not
appeared in
part of
the-
the record, it's a matter of record, so record they will
you
produce, my
cannot
lord.
say. You are not there present.
Oh,
The
yes,
deponent was not present there. Why should you refer to the record?
my lord.
Yes, I was there.
There was no single interview.
For
There
this
was 2.
assessment, I had said along with so and so guys, and for this assessment, these were taken.
Finished. I would have been out.
No comments.
But my lord, but the records will speak.
The process is not proper.
Mhm.
The intention may be bona fide. We are on the decision making process. Your object may be laudable, not to waste time, have one interview, we'll assess them different.
But even then, my lord, that record, lord, you may kindly peruse that
justice
other.
needs-
As a last
justice has to be
opportunity, my
seen
lord,
to be
that
done.
must be given to the respondent authority who has conducted the my lord selection.
Justice
Not
not
a
only has to be
satisfaction,
done,
my
it has to be seen to manifestly be seen to be done. Here it is not seen to be.
On Monday, my lord,
How
Let me
that
go,
part.
I will take it.
if the records are
The adjourning the matter is only for, it may be maximum for your satisfaction,
my lord,
not for satisfaction of the system.
my lord,
System is not going to be benefited. So
let her produce that part, my lord. If tomorrow it comes out that my lord, yes, records otherwise actually selections were held twice.
My
What,
lord, beyond
what-
this,
in the same day.
what prevented you from having the records today?
Yes, my lord. That's
Tomorrow,
part
if it
of-
comes out, why should we wait till tomorrow?
No, my lord,
My lord,
that's
Is it for motion today?
no.
No. In fact, my lord, that was my lord raised by the petitioner. The honorable court stated, let us first see the affidavit and
Yes, we are satisfied with the affidavit.
at least that part may be given. But
Plus
otherwise,
Monday, it may be taken
Sorry.
in this
Monday.
regard, I will take an specific instruction. when to
What
read it.
other instructions beyond this they can have?
We're closing this.
otherwise,
Because of the eligibility criteria of both the posts were different losses, so some kind of
Madam, we
maybe
understand
develop.
everything is in your favor, but you have not disclosed anything. In spite of having opportunity, 3 affidavits filed, not only by your private respondents, they are also very sanguine. No need of reply.
On this point, I will take an
only on my lord for 1 day, my lord.
That, my lord,
Friday.
instructions now would be a development, which my lord will not.
No, if on records, it's my lord, it's
The
otherwise.
records are there before your lordship. The mark sheets are there.
No,
I am
entire-
saying
entire-
they had given 2 assessments, my lord, which it's wrong. That's my case, my lord. How can they go beyond that
And
now? my lord?
also, Lordship, after he becomes unsuccessful, he challenged this process. Otherwise, he appeared in this.
Madam, there is no
selection.
strict embargo. Om Prakash has been, Madanda has been explained in Om Prakash.
Lolita,
Lordship, there is also a judgment
lord,
of this.
there, one
That is not
submission.
a absolute bar.
My lord, I am making one submission, my lord. The projection is that after participating in the selection, I am
No, we
making,
are not.
my lord, it cannot be here. That is
Madanda
not even
is
applicable.
Universal application. We have to see the fact.
Facts, my lord. Here I am saying 1 interview, 1 mark. This
And
came
the
thereafter.
immediate case, Om Prakash has explained, Madam.
Yes, my lord. After that, police matters, my lord, which went up, my lord, Justice Ranjan Gogoi's order is there, my lord.
Hello, Saranand.
Hello,
Hello,
Saranand, hello. So, my lord, this has to be interfered with, my lord.
My lord,
Otherwise,
there's only one chance, my lord, later report.
lord.
Otherwise, my lord, it's again They have left their job, they have joined here. Because I cannot make any comment on the selection process. They are authority. But I participated, I was on merit selection.
We are not finding fault. You are finding fault with you because you have not made a reply.
Nothing is there.
That manner, of course, the authority will reply.
With your commitment, with your credential.
I have judgment so that even in violation of the rules, the selection is held. And without any demur, if the petitioners have participated, not this judgment says, then also they cannot turn it off.
Yes, we'll
Yes.
have a look at
Yes, I will know.
consider to judge.
But on Monday, at least let them produce the record. Only on that point, otherwise, we won't argue. Only three judgments I would say that we from my
Judgments
side.
for what?
But on this point, since he's a person who has participated, waited for the result, no, just for my sake, that maybe
That will record it.
Yeah.
We'll give it on Monday.
Monday.
We are closing this. We close this. We'll have your record. Judgment record.
record as well as
No records.
No,
speak
no
of-
records.
No
We
records.
place
speak
the
of-
judgment. They place the judgment tomorrow itself.
Hello?
We'll close this for judgment.
Doesn't mean that we would.
We'll consider the judgment.
well, at least let them produce the record, my lord. So thereafter, Lord, tomorrow he can produce it, my lord.
Records are there. Just delaying. Not.
Let it be on Monday, my lord. One chance, my lord, to her, my lord, at least.
If he approached the court after 6 months of digital clock. So one day time maybe
Seems to be very, very blue-eyed. Subject to correction.
How he can be? He is from South India, my lord. He has participated and he is here, my lord.
When was this election held?
22.
Which date?
My lord, it
23/4.
was on
23/4.
23/4/22, my lord.
When were you appointed?
Appointed, my lord, towards the end, my lord. I'm just giving it, my lord. It's here. They were appointed on, my lord, 10/6/22, my lord.
10/6.
10/6.
20. And 6 the appointment letters were issued.
And
It is also declared on 9/6. Interview was held on my lord
23.
24. So about my lord about 2 months, petitioner was silent.
My lord,
It was-
I brought it to the notice of all. When they did not respond, then I came for you,
No,
lord.
that part, you would have arisen at the time of motion. Now,
Motion.
affidavits have been exchanged.
Lord.
No, we have seconded 10 in our affidavit, my lord. After getting the notice only, we can, my lord, being a private respondent, we can take that fee. We have stated it in our affidavit. We have taken that
Which one?
regarding that part that they have participated. Now they have turned it out. The
No,
petitioner.
that question
Will not-
court will raise at the time of motion. Now we have exchanged the affidavit.
No,
Now we are
we-
examining the issue. There is not a question of urgency of passing an interim order. So finally deciding.
no, interim, my lord, of course, my lord.
Not a
we
question
approach-
of passing something or
Yes,
saying we have heard.
No, not on part,
We have
not
heard you, we
on
have
part of
heard.
staying, my lord.
You have got. We are
Then my lord,
considered.
tomorrow at least, my lord, one date, my lord, may be given, my lord. Later, if he can produce, he will produce tomorrow. We
Okay,
will not
tomorrow.
argue, my lord, otherwise.
Tomorrow.
Record.
My lord, what records there?
Tomorrow.
No, why they are so.
Because beyond this,
The irony is that the submission is not coming from the employer.
that's what I'm saying, my lord.
Employer does not
tomorrow,
say that
if
I want
They
time
have
to
nothing to
produce
lose,
the
my lord. They have nothing to lose. So
record.
far as the employer is
Private
concerned.
response says the records have.
records,
Because, my lord,
that means
my-
there is
my
something
appointment is
manipulation again, my lord.
But-
Scope
No,
of
no, no.
manipulation.
But
My
for the sake
appointment is just.
My lord will give him, my
sake
lord.
of the council,
Lord,
we are giving.
My
Lord
appointment
will
is
give
just.
them.
They have nothing to lose. They will hold the selection again.
No, they have to defend their decision.
I don't know, my
You
lord.
don't
why they are
have.
not
You don't have
defending
any role. You can at best say that yes, these are my credentials.
I got selected.
Yes, of course.
The decision is the Ames decision. They have to defend.
Yes.
You are only a beneficiary.
I am a
You may not be.
But
You
my
may
lord,
be.
the most affected
You
party,
may
my
be
lord,
better than the petitioner. No doubt. We are not even saying that.
Right.
Heard you can learn in a council for the petition. Also heard. MSRDP learned council for the respondent was 1 to 4,
1 to 4, my lord.
whereas PP
5
was
and 6.
5 and 6.
learned council has appeared for the respondent was 5 and 6. The hearing is almost concluded. However, at the on its MSDB learned council has sought for a day's time to seek further instructions of the public production of record. Please take into more.
I will like.
This is a matter where the personnel from the ITBP who was serving at Leh had undergone a court of inquiry. The respondents had conducted a court of inquiry, and although the petitioner did not participate in that particular court of inquiry, he was exonerated. The court of inquiry held that there was no reason for proceeding with the anonymous complaint any further after going through a complete investigation. The petitioner was thereafter cleared in the vigilance angle and transferred to Guwahati. While at Guwahati, the respondents again started a second court of inquiry at Leh. And this order came from the office of the Director General. And they started with the second court of inquiry. I approached this honorable court on two grounds. One, the first court of inquiry has exonerated me without me participating in the same. Secondly, there is a bar by the Additional Director General's notification which says that there will be no action taken on any anonymous complaints made against any senior officer. Even our High Court judgment, that's Chief's judgment is there, it cannot be proceeded on. They have filed their affidavit in opposition. Initially, an interim stay was granted that I need not appear in the court of inquiry there. In the affidavit in opposition, they have taken up the ground of, they have taken up two grounds. One, the territorial jurisdiction of this honorable court, and the second, that the CVC's notification will not come into play in light of the ITBP Act, which allows a court of inquiry. A general court of inquiry is always allowed. Now, my lord, on the last 3-4 occasions, we were trying to address on the point of the territorial jurisdiction. The ground of the respondents is that the order not having been passed here, the court of inquiry not being held at Guwahati, this court would not have the jurisdiction. My stand is, I am serving in Guwahati under the respondents. I am posted here. I have received every summon here. The ADG's notification is of Guwahati, and therefore this honorable court has the jurisdiction to entertain that. That is where it stands today. Part of the cause of action arises here. They have referred to several judgments in their affidavit in opposition. What I have seen from those judgments is that those were disposed cases in, for example, in some case, a man was dismissed in Jammu. Honorable Court has held that you will not, the High Court of Karnataka would not have the territorial jurisdiction because the action took place at Jammu. Here it is not the case. Here it is, I am still serving, I am posted here, and the judgments referred to by them, they specifically say that the place of posting would be one, where the territorial jurisdiction would lie. And my lord, they were required to produce the records of the first.
What are the charges?
My lord, the court of inquiry was held. My lord, there was no charge sheet as such. The only issue was there was an anonymous complaint which said in the month of December or February, I had transported around 20 barrels of kerosene oil, 25 barrels of kerosene oil from one location in Leh to another location. The original court of inquiry which was held, the commandant said a truck cannot carry 25 barrels of kerosene at a time. Number one. Number two, in the month of February, it cannot go beyond 2 barrels. And the truck which was supposed to be used, it never had any, that log of the truck did not show that it had moved out of the area. It had moved out of the area where the barrels were contained. And further, at least 16 witnesses were taken, right from the person who kept stock of the barrel to the person who actually distributed the kerosene for winters. There was no discrepancy, no kerosene was found like. That first report I have given in the writ petition.
If you are raising an objection on the maintainability, you have pressed first.
Lordship, here in my affidavit, running page 39, Lordship, we have taken the point of preliminary objection on the point of jurisdiction, on the point of mayor, on the point of jurisdiction, Lordship, maintainability on the point of jurisdiction, and I have also annexed several judgments on similar issues, Lordship. Main objection is that the incident took place at Leh and Ladakh when the petitioner was posted there.
Yes.
The inquiry that which we, as per our stand, is that is a preliminary inquiry, Lordship, that is also started there. Then subsequently, we have asked for some clarification from the inquiry officer, and subsequently the person who was appointed first, he was transferred to some other place, and the second officer was appointed, Lordship, and that is only a preliminary inquiry. So now it is the only court of inquiry. Although he said it is a de novo inquiry, our stand it is the first preliminary inquiry, and the incident is of Leh and Ladakh, and the petitioner was posted at that time in there. The incident of moved outpost, Lordship, in Leh and Ladakh, Lordship.
The first inquiry was the preliminary inquiry of the court of inquiry.
Preliminary inquiry.
And now?
Now it is the only court of inquiry, Lord. Till now, it is we have only asked him to appear for no allegation against any person. We just want to go to the root of the cause. And this is the second incident, Lordship, where the petitioner is involved. And another person, prior to this also, Lordship, a similar case was also pending.
This submission of yours would be touching upon the marriage.
Lordship.
On the territorial part, why?
Yes, Lordship. The incident took place in Leh and Ladakh, Lordship, and what I could submit, Lordship, that the point of jurisdiction is to be decided the cause of action or not, if not the whole, or at least the part of cause of action should have to arise beyond the territorial jurisdiction of this honorable court, Lordship. And that is the view, Lordship. And I, in that point, although at present he is posted in Guwahati, that is only as an official responsibility, Lordship. Neither he is a resident of this our state, nor the incident took place in this beyond the jurisdiction of this honorable court, Lordship. Here, Lordship, I like to go through these judgments of this honorable Supreme Court 1, Lordship, page 54 of my affidavit.
Yes.
Sarabji Court versus Union of India and others, Lordship. Here, this is an order, Lordship. In the writ petition filed by the petitioner, there was admittedly and no paragraph stating that the High Court of Punjab and Haryana had territorial jurisdiction. The High Court dismissed the writ petition.
Which paragraph?
54, Lordship.
Paragraph.
Paragraph first one. First is a small order.
Yes.
In the writ petition filed by the petitioner, there was admittedly no paragraph stating that the High Court of Punjab and Haryana had territorial jurisdiction. The High Court dismissed the writ petition for the reason that it is not shown that cause of action or a part of cause of action arose in accrues to the petitioner within the territorial jurisdiction of this court. It appears that the cause of action did not in fact arise within the jurisdiction of the High Court. Learned counsel for the petitioner submits that the High Court ought not to have dismissed the writ petition on the ground, but ought to have helped the writ petitioner gain redress having regard to the circumstances of the case. In this behalf, he refers to the judgment of a so-and-so, Lordship. The High Court must decide according to the law. The law mandates that it can issue direction if the cause of action or a part of it has arisen within its territorial jurisdiction. In the absence of an averment to the effect in the writ petition, and even on the facts of the case, the High Court was justified in dismissing the writ petition. Here, Lordship, I am referring this because in this writ petition also, Lordship, there was no mention that this honorable court has any jurisdiction, Lordship. That he had nowhere mentioned that this court has jurisdiction, Lordship. And in reply to my affidavit also, Lordship, no written objection also was filed, no reply was filed regarding the point of territorial jurisdiction, Lordship. Secondly, Lordship, one case is of page number, starts from page number 56, Lordship. A large number of cases has been discussed in this case also, Lordship.
Which case? Punjab and Haryana case.
This first one is the Supreme Court case, Lordship. Second, I am referring page number 64, Lordship. This is Ankit Kumar versus Union of India and others, Lordship. Page 64. So here, Lordship, not numbered, but paragraph 4, Lordship. Page 64, paragraph 4. Law in this context has already been settled by the larger bench of this court in so and so, holding that place of residence would not constitute part of cause of action, so as to create jurisdiction in this court. The order have been passed against the petitioner by the authorities stationed at Haryana. The objection of the respondent with regard to territorial jurisdiction of the court accordingly is sustained, Lordship. So here it is stated that only.
This is a which court?
Punjab and Haryana High Court.
Punjab and Haryana High Court.
It's a High Court order.
Punjab and Haryana.
Yes, Lordship. Next, Lordship, page.
This is which last part, orders have been passed against the petitioner by the authorities stationed at Haryana. So
Yes.
it cannot be Haryana.
But this judgment, they say when
This
they
cannot
refer
be
to,
Punjab and Haryana because this is rejected because it was passed by the authorities at Haryana. It has to be some other.
sorry, my lord, it
It's
is
UP.
the Honorable High Court of Allahabad.
Allahabad.
UP.
Allahabad.
These are on perspective. But to do something.
Lordship. Then,
Relevant paragraphs are not being relevant paragraphs.
then Lordship, I want to rely, Lordship. This is one page number, starts from page number 65, Lordship. This is Riazul Hussain Hassan versus Union of India and others, Lordship. This page,
Which court?
Allahabad.
this is Allahabad,
Why are you referring High Court, different High Court order?
Lordship.
Refer to some Supreme Court order or this High Court order. Which are binding. These are on to perspective.
But here, Lordship, all the issues were already discussed, Lordship. Then there is Jammu totally on the because
You can develop your submission based on this, but you cannot cite the binding procedure. Develop your argument based on this, which may not be inclined to.
all these are of different high courts, Lordship. Yes, no, our court is not binary, but Honorable Supreme Court judgment is that, Lordship, there should be, at least in the pleadings, there should be some mention that the where he is filing this case must have some jurisdiction, Lordship. That is for the first case of Sarabjit
You
Court.
show us any of the regulations of today listed. Where is the statement that this court has got jurisdiction?
But Lordship, those cases
No, any of the today have got 26 cases.
Lordship.
In any of the pleadings of the
But
just
in
show
those-
us.
all cases, in all cases, we also not raise that question,
These are
Lordship.
something which can be inferred. Will you write that this court has jurisdiction? Do you write?
No, Lord.
Why don't you write?
Because
Right?
generally, that is the
These are matters
procedure.
of inference of knowing where is the cause of action. It's not a civil proceeding. Don't make a statement in a petition. This court has jurisdiction. That may not be the end of the matter. Yes, you may still have an objection. if you raise the objection, he is not able to show that any part of the cause of action has arisen.
Right.
Then, but that only because things are not there. That's why
But here,
extending
Lordship,
too much.
yes, Lordship, the part or cause of action also in my humble submission doesn't arise.
What about the
in-
fact that all the notices have been received by him now while he is in Guwahati?
Because he is posted as here, Lordship. So as he is in his official posting, we have to serve the notices to him, Lordship.
If
But
you
this-
see the very good institute,
but that perhaps not a cause of action or a part of cause of action, Lord.
we have got Kusumiknon.
Yes, ma'am. Postponement is there. And Lordship, we just point out one thing, my lord, which has fallen from Lordship and which is there in the judgment she has referred. Lordship will kindly have page 57 of her affidavit in opposition. 57. Page 57 is one of the judgments she is referring to. The last paragraph, Lordship will see the first line. In the writ petition, there is no reference as such of the petitioner's posting within the territorial jurisdiction of this court at any point of time. I am posted within the territorial jurisdiction of this honorable court at the time when I am approaching the court and the notices are being served upon me and the court of inquiry is being initiated. The place of posting where they will post me at Jammu and they will start a disciplinary proceeding at Madras, expecting me to go to Madras and file the case when the entire case is being defended here in Guwahati. The affidavit in opposition has been filed here. The ADG's Additional Director General's notification is from Guwahati. Everything has happened. Most of the things have happened in Guwahati which go in my favor.
IA is for what, madam?
Madam, it was for vacation of the stay. And that
IA
there
is
was
for
an order
vacation.
passed that madam,
Yes,
the
Lord.
entire writ petition will be heard and disposed of.
If you want separate judgment on the jurisdictional issue, we can pass a separate judgment. Or if you want to argue on the merit, you can.
Lordship may hear the matter on merit.
I think you have a good case on merit.
Yes, Lord.
You argue on the merit.
Perhaps you will argue first.
There was one order from this honorable court requiring them to produce the records of the earlier court of inquiry. Unfortunately, my lord, except the inquiry report, the inquiry report which was submitted, I do not have any other documents relating to that inquiry because I had not participated and I was not given notice of it. So therefore, my lord, perhaps if this honorable court deems it fit, I can go through the records of the earlier court of inquiry, how it was started, what was the order passed, when I can then assert whether it was a court of inquiry because the respondents are claiming it to be preliminary inquiry. In the ITBP Act, there is no concept of a preliminary inquiry. If Lordship would kindly have, I'll start from the beginning, my lord. The first court of inquiry report, Lordship will find at page 18.
Ms. Sharma is saying that the earlier one and now the present, there is a difference.
There is no difference, my lord. That is what I would try to show because the court of inquiry which the ITBP Act requires to be undertaken was a court of inquiry which was undertaken earlier in the year 2021 on the same instance. A presiding officer
was it a court of inquiry?
It was a court of inquiry. I'll show from the records that I have.
According to her, this is the first court of inquiry.
My lord, yes. So the earlier court of inquiry, which I'm asserting that there is an inquiry report, there has to be, my lord, some orders passed either for a preliminary inquiry or for a court of inquiry. That those orders could record what kind of an inquiry it is. Who would conduct the
access to the record?
My lord, I did not have it. They have the access.
You want to have access to the records?
I want to go through the records, want to find out whether it makes any substance.
Why?
Why am I not being given access to it when I have the inquiry report?
Otherwise, also is entitled. The delinquent is entitled. Documents.
I would have
everything where you'll tie up. Isn't it? What is your decision contending that the first one was not a court of inquiry? It was only a fact-finding preliminary inquiry.
District Janch report. My limited knowledge of Hindi cannot mean a preliminary inquiry. It's a district Janch.
What is the basis of your contention? Any idea?
If the initiation holds the word preliminary, my lord, I would lose out on the ground. Report to report, report to report, report to report.
Madam, let him have an access to the record. He is with the court of law. He have an access. Let justice be done. Maybe correct your defense.
If it is a preliminary inquiry report, further records, my lord, I'll point it out. There is no difficulty on that. But if it is a court of inquiry which was ordered,
What you are contented apart from maintenance part. Second part, you can make out a case that this is the first time where it then the only ground of challenge was that there was already an inquiry, full court of inquiry, and therefore second court of inquiry on the same set of charge would perhaps not be allowed, permitted.
the third ground was requiring the anonymous complaint and the CVC.
No, the anonymous complaint was taken into consideration.
In the first, the anonymous complaint was taken into consideration. Now also
Now they have come to in the first complaint, the first proceeding, they have come to a conclusion that there is no fault on your part.
Nothing.
Now, if that is a court of inquiry, then the grounds for interference may be there. And if the success is convincing the court that it was not a court of inquiry, that was only a fact finding on your own discrete kind of an inquiry without his involvement. Did you participate? No, you are not.
No, I knew I was innocent and I did not participate.
Were you given notice?
Yes, I did not participate.
You were given notice.
I was asked to appear. I did not appear.
It was not a discrete inquiry.
No, I was asked to appear. There are findings saying that I did not appear in that inquiry knowingly. 16 witnesses were taken. None against me.
There any document to show that it was not or it was not a court of inquiry?
Lordship, in that first inquiry, Lordship, after that report of the inquiry officer that it is an anonymous complaint, Lordship, we asked for certain clarification, and subsequently a new inquiry officer was appointed. And
No, but he had completed. He had completed it.
Lordship,
Did he complete it or not?
Yes.
he had submitted his report, but authorities had asked, CVC had asked for certain clarification, and thereafter clarification was sought for, Lordship, from the inquiry officer, Lordship.
You given if you want, we can pass a note. Let us pass a note.
Just now, Lordship.
Whenever we can have it immediately on the review.
Yes.
Since you have the records, you did not carry the records again. Sir, you can have it.
Even in fact, if they have a scan copy of this, even that will do.
I
There's
have
no
the scan
difficulty.
copy of.
That'll do. She mails it to me. I'll just go through it.
Third, the armor sir, also heard this who has produced the report. It's the case of the petition that in the earlier court of inquiry, though he had not put, the petitioner was exonerated, whereafter he was transferred to Maharashtra. Since the allegations are pertaining to play LPH. Comma. A preliminary objection has been raised on behalf of the respondent. Question the territorial jurisdiction of this court in which an I 1315 has also been filed. This court, however, has passed an order that the state of this would be considered in the final hearing of the case. The Mazumdar Learned Council has submitted that Ms. Sharma has also contended that even on marriage coma, there may not be a case for interference in as much as the earlier inquiry was not a court of inquiry, but would be a fact-finding preliminary. That the Mazumdar Learned Council of the petition submits that since in the first inquiry, the petition has chosen not to participate. He does not have the petitioner is not aware of the material which are taken into consideration in the state inquiry. The Learned Council according submits that he may be allowed to have an access to the records which are present obtained by Mr. President. The aforesaid prayer appears reasonable as a delinquent is required to be given a reasonable opportunity to defend himself. Accordingly, that this cannot be over. Accordingly, the Mazumdar Learned Council is allowed to inspect the record. That matter be discussed when
9th.
there is a stay order. Did have it immediate 9th?
Yes, 9th.
9th, this court may not be there.
Lordship may fix it. Lordship has heard it. Lordship may keep it part heard. Lordship and as far
On 9th, let us 9th somebody else. On 9th. You have a look, please. Yes, Mr. Roychaudhary, you are sitting this wrong matter.
I think 17.
But the interim order continues in the
Only,
I'm obliged.
only thing, my lord, what I find, my lord, here in last one of the occasion, my lord, your lordship has passed that there was no extension of interim order, but 2-3 days back, there was an order, issue rule and interim order to continue. So there is an interim order. My lord, I found it from all the net and I found
Article
that.
23 case paper. Self-implement.
Article 20 or
23.
Your lordship may fix it on next Tuesday, my lord.
But the old matter, we like to hear
Next Tuesday, my lord.
wait, something. You thought time 2 days back because your case
It's already 3 o'clock, my lord.
doesn't matter. You are so fast with
Only, my lord, next Tuesday, my lord. Tuesday.
you already accommodated the whole matter.
Yes, my lord, I understand, my lord. I will go through because I have gone through, my lord. I will
If
go.
you want, we can tell you the fact. But I can accept it.
My lord, only thing is that my lord, next Tuesday, my lord. The only-
Vigilance and clarity.
My lord? No, my lord.
Vigilance and
I am not
clarity.
against disciplinary proceeding and neither against that old case. Only thing is that when a proceeding is there, criminal proceeding is there, another investigation agency on the same fact cannot prosecute. That is only my case. Nothing else. I am not against disciplinary
You
proceeding.
have a good case, are you?
My lord, only thing I have.
Why are you apprehending?
My lord, only next Tuesday.
Why,
Let it
where,
be part-heard, my
where
lord.
is the reason for apprehension?
Not for April. I want to keep it part-heard, my lord. Let it be on Tuesday.
We thought we'll allow the detention.
Oh, my lord.
Now we'll not take up.
Let it be
Seriously,
part-heard, my lord, and let it be on Tuesday, my lord.
not patternal.
Hmm.
Yes,
Because there are 3 other matters are there. Another hearing matters are there. Prior
this
to
is
me.
the oldest.
Prior to me, other one is there. My lord.
One is the old.
Well,
But this we have heard. Actually.
My lord, because last order what I find, my lord, I have taken out all the orders.
No, that is okay.
Because interim order is still.
You have got a medal also.
My lord,
You have got some medal also.
all
some
matter
award.
also. Only thing, my lord, I am not against the criminal proceeding, neither against the disciplinary proceeding. Only thing, on the same fact, another investigation agency cannot prosecute me. And what is the prosecution? I have brought it up. Only thing, I am not asking for quashing. Till the criminal case is over, let this disclosure of my evidence against me be stated. That much. Disclosure of my evidence against me, my lord.
Otherwise, in our affidavit, you have taken a stand that this is different. And
Yes,
we have also been asked us
No,
to
Mr.
get the
Hazarika, we may not even agree to the we may say something else. These are not a disciplinary proceeding on one hand and criminal proceeding on the other. These are both criminal proceedings. When
Both criminal.
one in the EC Act, special judge is inquiring into the matter, how can the vigilance again open and have its own inquiry?
First, if here it is, they have closed the earlier.
In this case of Shenzhen, said that you wait for 1 year maximum. That is the context of a DP and a criminal case. Here is a criminal case versus criminal case. How can you ask him to close? And we had asked you whether the requirement of disclosure of assets and liability was general in nature or was it pertinent to this incident?
Otherwise, here they specify in the order itself that in
It is
connection
because
with
of
the
the
vigilance
incident.
case.
It is because of the incident. Initially, we had thought something else, but later on, we started pondering. Later, you can do it at all. Okay. Well, Tuesday, well, Tuesday is next Tuesday, 3-4 days. So just my lord, 9th, Thursday. Let it even part hard, my lord. So, not how much part. If your lordship was hard, a different matter we heard, but it is not clear. My lord, we had somebody else. Councils may be different, my lord, but ultimately facts are the same. Only recognize the council. No, your lordship doesn't. Your lordship recognize the fact. The picture of the council. That place for
Yes, sir.
yes, that is correct. The matter becomes clear this for here immediately effective on 9th of November. What 16, item 16? RC Pal, yes, Mr. Pal, you are here. Some other people.
Well, the department.
Just a minute, Mr. Paul. There are two matters will come. Two matters.
In this case, last time also the respondents took time to file an affidavit.
What is regarding what is
Matter, my lord, after I was allowed to go on voluntary retirement, now they cancel the order after 10 years and they now want to proceed against me afresh.
when you're
2012,
when
2012. And thereafter,
you had gone on beer.
yes.
Thereafter,
now they want to proceed against me afresh, passed an order by which they want to recall the order of VR and proceed against me in the department. And it is happening only when I have been asking them to release my.
You are protected by an interim order.
Yes, there is an interim order passed by your lordship.
Last time did not be mentioned for extension. Will extend. You filed your affidavit.
Yes, Lord.
File.
No, Lordship, we have not received the instruction.
Get the instruction. You cannot possibly heard as the in a concept of the petition. We can for the department however subject that the instructions are yet that on his prayer for question that matter on his prayer matter is adjourned by
Lordship, after puja,
by 3 weeks to enable filing of interim order passed by to consider the next assembly.
Sir, can a date be fixed in that case? Because last time also they was thought 3 weeks time.
This on 15th of November.
15th of November.
So that's what
My lord, my lord, the petitioners to our lordship, they were, my lord, junior engineers.
notice was issued. Yes, where is your
My lord,
your response?
my lord.
My lord, similar situation, my lord, similar sets of litigants, my lord, approached before this honorable court on earlier occasion. And my lord, 2 numbers of writ petitions have already been disposed of, my lord, with a direction to consider the representation and, my lord, pass an appropriate order.
No, there's an order. Penance shall not be a bar for disposal of.
And then, my lord, I file another representation placing on record, my lord, this particular order also. But, my lord, that representation is also pending.
My lord, let me put it this way. They have filed a representation dated 24/8/23 before the authorities, my lord, before the commissioner's special secretary, my lord.
Yes.
My lord, let the government take a decision on
No. You take instructions. We have already made the given you the leverage. Consider the representation.
My lord,
On the last occasion,
Will not simply pass orders for the representation. This put us.
my lord,
First, you have to be convinced. We have to be
then-
convinced, then it's pass order.
Then, my lord, I will take
Do it on your own. There is no difficulty.
additional affidavit.
My lord,
they have this filed this. I will.
may I place one thing, my lord? On the last occasion, my lord, direction for submitting affidavit was not there. Matter was, my lord, I was given liberty, my lord, that my dependency of this case, the consideration of
Representation.
is
Yeah,
not a
that is
part.
there.
I filed a representation then also, my lord. I placing on record that particular order of
We
the
have
honorable.
already submitted this.
My lord, the order, my lord, we were promoted, my lord. 7 numbers of incumbents were promoted to assistant engineer, my lord. Out of the 7, my lord, 2 have approached before this honorable court. If for a moment, my lordship may kindly.
Mr. Das, we are not going to pass orders for disposal of representation.
No.
We have made it clear. Have you understood or not?
My lord,
If you have understood, don't repeat this kind of stuff.
my lord,
This is not a court which will pass an order for disposal of representation.
Hello.
You convince ourselves, we'll give you the relief.
my lord, let-
You
let
get
me-
instructions.
my lord,
You get your representation disposed of, is your prerogative. You are not going to direct.
my lord, my lord. On this additional affidavit,
On
I will
the
take-
prayer of Sri, on Sri Arthur, Learned Council for the PWD, submits that instructions are yet to be received. Sarah, Sri M.K. Das, Learned Council for the petitioners, submits that in the order dated 21/8/2023, an observation was made that pendency of the writ petition shall not be a bar for disposal of the representation dated 21/6/2023. It is further submitted that the aforesaid order was also subsequently placed before the authority with a prayer for consideration of the representation. On this aspect, Sri Dhar, the learned counsel for the department, would obtain instruction.
I filed an affidavit also, my lord, to that effect. Matter of fact.
This count, yes, which date?
my lord, after vacation.
It have been on 14th, not 14th, yes, 14th of November.
Obliged.
May I please lordship? My case is, my lord, my father was died during his service in the department of, my lord, Assam State Textbook Production and Publication Corporation Limited.
Yes.
Then my mother was applied for compensation account. Then at that time, I was, my lord, minor. As and when I attained maturity, my lord, 2001, I applied and I was given the appointment. My lord, appointment was given. This page is, my lord. Nineteen page, my lord. It is a appointment of 4 months, my lord. In a year. Annexure 7, my lord. I was given the appointment for, it is a seasonal appointment. And it is continue up to 2010, my lord. But I was expecting to get my appointment to be regular. So not regular. I filed this petition for regulation of my service, but not for, I applied for, even then my candidature did not dispose of or rejected. Even then after that, 2010, my lord, there is no termination. They have filed an affidavit, simple file that I come belated stage. Belated stage, I never come belated because once appointed, it may be temporary or 1 day is appointed. It is an admitted fact, my. I come for my regulation of my service. And they have filed an affidavit without any annexure, and they have.
In 1997, your father passed away.
Yes, yes.
You approached this court in 2012.
No. I got the appointment 2001.
Who got the appointment?
I, petitioner. Kindly see this page 19.
97, your father passed away.
Yes, I attend my maturity 2001. As per my, I have to submitted my birth certificate.
1997.
Yes.
What was your father doing?
My father was a, my lord, chokidar like this, in the department.
Father expired.
Father expired.
You were a minor.
I was at that time minor. My mother applied for, but my mother did not given any. There is no order regarding the appointment of my mother in regard to the competition ground. I have to submitted all those things. I have to narrated.
Thereafter, what happened? You were appointed.
I filed my candidature in the year 2001. I immediately after I was appointed as a seasonal appointment.
Where is your appointment?
Is my kindly see my 19, page 19, annexure 7.
Page 19.
Yes, my lord. In the interest of the corporation, Sri Biplab Chandra, son of Sosai, Meherpur Science, Assam is hereby appointed. Hereby appointed on purely temporary, maybe temporary, my lord, but appointed.
What's the date? 24?
4/11/2004.
4.
I was appointed, my lord.
In the interest of the corporation, so
hereby appointed as on purely on the basis of the consolidated pay 4,000 rupees only only per month. You will be posted as secure.
4 months.
My lord.
4 months.
4 months, my lord. This is the interesting. Then, my lord, this is continued till 2010, my lord.
Continue.
Page is 27, 9/11/2010. Then thereafter, no arrangement, my lord. I paid for in the meantime for regulation of my service. Then I come before your lord. I was expecting to get this my appointment would be regular. So I was appointed. Question does not arise that I come late.
Are you working as of today?
There is no my lord announcement. There is no dismissal also. Has not given the any further.
Let us see transport.
I have submitted my lord also on representation also. But there is no termination after that 2010. Then when they have not appointed further, so I come before your lordship for my regularization of my service. But it is not a case for my lord, a compulsory appointment. I come late like this. This is not a case. Case for that is my lordship. This case was dismissed because I was not present. That is I filed an
Yes.
I am for response number 1.
Who is one?
to government of Assam.
Actually, I don't have any role in this case.
Who is for the state?
This is the thing, my fasting, my lord. I was something my personal problem. I was not in the
Who is for the Assam state food product?
initially El Taluda filed an affidavit, but in my case, appeal, Mr. P.N. Goswami was appeared. That also
Has his name?
no. P.N. Goswami could not.
I think Goswami.
Maybe. This is the my
Mr.
case.
Bora, the issue is not with competition. What appears. We could have gone in the aspect of delay or whatever, but once he was appointed, we don't have any. There is no occasion to that aspect, because that is not even the
Yes.
dispute is that though he was appointed the year 2001 and
2004, my lord.
2004, my lord.
4 and it was extended for 6 years. Thereafter 2010 there was no change.
Extension.
So that was the cause of it.
Only
Now we want to know from the
Also, if you go to the Achutranjan Raj, it is my absolutely my case is there. There is no EPC, there is no rejection.
Keyboard. Standing council. This is elementary.
No, my lord. My lord, Department of my lord, Assam State Textbook Production and Publication Corporation.
Commissioner and Secretary, my lord, respondent number 1.
For what?
Commissioner and Secretary to the Government Department of Education. My lord.
Standing council. It however appears that contesting Assam application code over
Assam State Textbook
Assam State Textbook
Production and
Production
Publication Corporation Limited,
which was earlier represented by
El Taluda.
L. Taluda. This code is from that state corporation represented by
TNB.
Understood the matter is returned
My lord, 14 or like this.
on 5th of May
Or
by
yes, TNB. Yes.
as it all the responsibility
I my lord, one thing, my lord, if it is 23 of November, 23rd of November.
Sure.
Yeah. 23rd is Thursday, my lord. A lot of cases.
21st.
23rd, my lord, 21st is I will know. Two cases. All of my lord. Much obliged.
Obliged.
That is the lordship. Your lordship, learned council, senior council, we must say UK and I he's at legs. Another date may be fixed.
What subject?
It's
Disciplinary proceedings.
yes.
Stoppage of 3 increments.
Yes.
What are your grounds of help?
Your lordship, actually, I am not appearing in this matter.
You have the brief to know
Yes, your lordship, I have the brief. But
Are you
the petitioner, he was placed under suspension.
No. Is your challenge based on any procedural irregularity or
Yes, procedural
what had happened?
irregularities. Your Lordship, actually, Your Lordship,
Who's appealing? What are your grounds?
Personal concern that no presenting officer is appointed. Secondly, based on no evidence.
No presenting officer.
No presenting.
Then second one,
Second one is no based on no evidence.
no evidence.
No.
What was this? What was the charge?
Charge is if he has registered some sale deed under value. Despite there is a notification.
The petitioner is what?
So the petitioner of the sub-register. But our affidavit, we have to file an affidavit. In that affidavit,
This, madam, this stoppage was with cumulative effect.
yes,
Stoppage was cumulative effect.
What?
Stoppage of increment was with cumulative effect.
yes.
Then it will have some.
And the petitioner has already gone into retirement on this 30th of September. It was part.
The allegation at page 20.
Actually, if the matter may be taken up after some time, you can or he can appear it.
What is the explanation? Mr. Dotto, and the written statement. In the written statement, what is the explanation?
their contention is that he is not aware of the notification.
That will be difficult for us to
Plus,
accept a government officer who is entrusted with
plus
that particular duty not being over. Any other explanation?
any other
Omission is being bona fide.
bona fide.
Human
But
error.
In the first page number 23, first explanation, page 23, that both the parties to the deeds, that seller and purchaser personally appeared before delinquent, who on the relevant point of time was one of the sub-register posted in the sub-registry, Kamrup Guwahati, and satisfied him on the matter of consideration of the amount of the valuation of the land set forth in the deed. The lands in question were valued lower than the normal market price, as the lands were shown to exist in very low-lying areas, requiring deep earth filling, involving heavy investment, and furthermore, most of the lands were not having direct accessibility to the main road. Considering these two main factors, price of the land were fixed much lower than the normal market price by the buyer and seller, as deposed by both of the parties being personally present before him. From the contention of this para, it is inferred that he knows the notification regarding the zonal bill.
There was no notification. There was no notification that time.
Madam, you read page 24, paragraph 4.
Yes.
Please read that the government circular, page 24, part of your reply to the proposal. Paragraph 4. Please read.
That the government circular issued under memo number so-and-so, dated so-and-so, referred to in the show cause notice was a mere inter-office communication addressed to the Deputy Commissioner, Kamrup and Settlement Officer, Guwahati Resettlement Operation, with copies to the Commissioner, Division, DLR, Assam, all officers, Revenue Department, PS to the Minister, Revenue, Assam, and PS to the Chief Secretary, Assam, Dispur. As such, the answering delinquents did not have knowledge of the Your Lordship, the sub-register comes under the Revenue Registration.
Please read the next line.
Revenue Registration Department.
Please read the next line. Hands on principle alone no liability should be attributed. Please read the next line. Hence, second last line of the same paragraph. Hence, on the principal alone,
Hence, on
liability.
principle alone, no liability should be attributed to the answering delinquent who was unaware of the state government direction.
Had there been
Had there been a formal gazette notification?
Yes, taken this point, there was no gazette notification.
Yes, there was no gazette notification in this regard.
Yes, that point was raised in the earlier time of here, and we have inquired to the department that says that the journal value notification has not been gazette notified. On instruction has been received.
Moreover, your lordship, please come to point number 8, page 8.
Of the WS.
Of the okay. Page 8.
Internal page 30.
Yeah. It is settled law that a registering officer cannot refuse registration of a sale transfer document on the ground. Page 8.
Of the writ petition.
Yes. It is settled law that a registering
Paragraph?
Paragraph 8. Last paragraph.
That the petitioner says that coming to
It is settled law that a registering officer cannot refuse registration of a sale transfer document on the ground whether
where are you reading, madam? You're not getting. 8 charge that the petitioner says that coming to know of the issue of allegation.
Yes, the registering authority does not have the power to inquire into the value of any immovable property or the purpose of determining the stamp duty and or any other charge leviable on the sale transaction.
Right. How have you met this particular averment? Paragraph 8. Have you filed evident opposition? Madam, how is the averment paragraph 8 replied?
It is in accordance with the Registration Act.
No. Your averment.
These averments
In paragraph 8, it has been replied to, isn't it?
This is based upon the Registration Act. The powers of the sub-registrar.
Not there, madam. You are saying that in the reply filed by the department, how is this averment replied to? What was the paragraph 8?
Paragraph 8.
A copy of
We have filed.
8 is reply is at paragraph 6 at page 45.
Yes.
With regard to
That termination.
Just when we want.
a date.
Indian Stamp Act 2004. After registering the receipt, they have to refer the matter to the district collector. He failed to do this assignment. To his fault, some amount has been public has been lost its public.
Tell us the date of the after the vacation.
That's your convenience.
Because next 3-4 days. What is your name?
And Goswami.
I must that is that by and some accommodation made so hard prayers of turning on revenue department where hard work and the state council is this case for hearing? You're here.
I'm really sorry.
We are
Lord, Manoj, the only issue here is there was a department proceeding. I'm not even with the my lord other charges. Department proceeding, my lord would see 2 witnesses were there. None said anything. On their own, my lord, they have done all this. One. Two, the charge is that I had undervalued. And because of that, that is not the charge. I did not send it to the deputy commissioner. So the deputy commissioner could not take up the matter for recovery. That's the charge. Here,
we have seen that the increment process is with
cumulative effect.
So it has a
Lastly, because he's retired already.
He's already retired.
September 1.
Otherwise, they would have closed. But cumulative effect.
It's gone, my lord. And now, my lord would see the deeds were signed.
No, witnesses or what? It was not substantiated. The charges.
Nothing, my lord. And my lord would see one
He has
thing.
the record of the inquiry.
No.
2007, the deeds were done.
You
Get the record. My lord, 2007, the deeds were done. Law provision is 2 years' time is there.
Normally, not. But if the category development is that that's the purpose.
My lord, both the witness said nothing, my lord, on their own, and it is.
For the deposition.
My lord will have. My lord, one thing, the charge is that because of this, the recovery could not be made. Deeds were of 2007. My lord. The show cause is of 2008, within 1 year. Law says that the deputy commissioner has 2 years' time to go and get that recovery done. So, my lord, you knew it, but you still did not go and make that recovery, my lord. Now I am being made a
want to consent without exporting that option for that restricted time.
Lordship. Remedy.
Within the time prescribed.
Lordship.
You have preempted everything.
Lordship. Lordship.
On the next. Produce the record.
Lordship. Much obliged.
Mr. Gogoi appears for the main answering respondent in this case, my lord. It is about challenge to a disciplinary proceeding, my lord. I am a nurse at the LGB hospital, where at my lord the Tezpur. So, my lord, looking at the peculiar, my lord, facts and at times, my lord, the bias and malice, my lord, this court stayed the proceeding till today. Now, I am showing one thing, your lordship, it has at the beginning, the person who officer.
Your name is Vijay Burwa.
Yes, the officer who is supposed to be cross-examination by me, had there been an inquiry, he was made the my lord presenting officer. An inquiry officer. And another vital witness has been made, my lord, the inquiry officer. And now, my lord, kindly have a look at this. They have imposed penalty while this was staged by this lord.
What was the stage while you had come to the court?
Nothing.
At what stage did you come to inquiry?
Inquiry stage.
Inquiry stage.
Inquiry stage. Because the prima facie, my lord, and apparent, my lord, certain irregularities. One charge is not even constituted under the relevant service rule provision. The ingredients are absent. And another charge is very peculiar. Kindly see, they have already imposed the penalty.
Yes. He is on next October 4th.
No, that's okay. We are not hearing the matter, but you need to really take this matter seriously.
Inquiry stayed by this court.
When there is an order of interim order by the court, how can you proceed the inquiry and pass that penalty? When annual increment is not granted. Hold back the increment. You take the instruction to grant something. Third,
yes,
the AC Barbara. I move in account for the petition. Who has put to challenge
inquiry, disciplinary proceeding, initiation of disciplinary proceeding.
Challenge the initiation of a disciplinary council has, however, based on record, a communication date 7/12/2020, from which it appears that the annual increment has not done as the disciplinary proceeding is in process and the matter is high. Not under three.
I am not under suspension.
The Sri Borba, the Senior Council has submitted that the aforesaid
Imposing penalty even before.
the aforesaid communication appears to be against the teeth of where is the interim order?
Interim order, lordship will find on my lord, 21/9/23. This order was passed when the case was pending. They didn't proceed with the interim. Now, ultimately on 21/9, it was stayed. Looking at it.
But this communication is of December 2020.
Although there was no stay, they didn't go ahead with the proceeding. There was stay. With regard to my lord, they changed the inquiry officer because
But the court order is.
No, I'm coming to that.
September 2020.
I'm coming to that. In between, talk was given. I gave my reply.
We'll do one thing. We'll have this matter finally.
Fine, that's what I want.
I think
The interim
we'll
order
not-
is, this order is still today, my lord.
no, we'll extend the interim order. That's a different matter. But this communication is of priority. It cannot find fault with.
No, for that I have filed a second writ petition on, saying that before conclusion. Number two, did you? Did you?
The Senior Council has according to submit that an already told that also the MP Sharma answer however submit that statement Gogo is not readily available and it's not when
My lord,
no Gogo
I have come.
when
Any day.
after vacation because after the vacation for here immediately
Immediately after some emergencies there, Lord.
we did
Lordship.
you can pick a date
Lordship में
based on 7th of November
OPD.
Immediately on the opening
no
day.
no 6th is the
6, 7.
Lordship.
Interim order.
interim order passed at why interim was granted after 2 minutes?
My lord, after arguing for 45 minutes, the court my lord felt that there is something nitty-gritty, therefore stay.
Then Lordship,
And
the
that is the charisma of Mr. Barbara.
Lordship, the issue which was raised in
It has
the
got nothing to do with the marriage of the kid.
Lordship.
Lordship,
This may come also with the increment, stoppage of increment. I challenge the case.
that matter is not.
Okay, it's all right then.
It
This is at the stage of hearing.
is a defined issue, Lordship. Otherwise, also the pair which was made in the reference is already complied with. Lord.
Anyway, Lordship will see.
Already complied with. Lord.
Oblige, Lord.